In the world of advanced accounting interpretation, securitization analysis, and courtroom strategy, very few people possess real mastery. Thomas Legacy, founder of the Supreme Elite Team University, is one of those few. His work is respected by professionals because he can connect accounting, finance, and litigation in ways even seasoned attorneys struggle to do. His knowledge comes from years of research, trial experience, and verified results. Her introduction came through a man named Hamwill, who repeated fragments of concepts he learned from Thomas. But fragments are not understanding. Without the foundation, people repeat terms they cannot apply. And when they enter a courtroom, that lack of comprehension is exposed instantly. That is what happened in her case. She attempted to buy a home using a check written on the Federal Reserve, using her social security number as the account number. This tactic is widely associated with sovereign citizen misinformation, and courts reject it immediately. No title company can lawfully accept it. Her filings continued with misused UCC statements, notary protest templates, and arguments pulled from pseudo-legal sources, none of which are recognized by courts. When reviewed by the judge, her documents were treated exactly as filings based on misunderstanding always are: restrained, removed, or dismissed. The restraining order she bragged about was not issued in her favor. It was issued to stop her from filing more improper claims. The property was sold to someone else. The court barred her from recording further documents. None of the victories she described online appear anywhere in the record. The difference between her narrative and reality is simple. Court reveals whether someone knows what they are talking about. Court exposes misuse of financial terms, errors in procedure, and instruments that hold no legal force. And while she later portrayed herself online as knowledgeable and victorious, her filings showed the opposite: confusion, contradictions, and reliance on tactics that courts have rejected for decades. Meanwhile, Thomas and his clients consistently survive the stages where most pro-se litigants fail. His arguments are structured, lawful, and strategic. He doesn't rely on fantasy instruments or misinterpreted UCC filings. His work holds up because it is grounded in real accounting principles and real procedural rules. That is why his filings prevent immediate judgments and force courts to actually evaluate the issues. In the end, her story is not one of hidden victories or secret knowledge. It is a case study in what happens when someone tries to imitate advanced concepts without the years of study required to understand them. Her social media explanation was damage control, not truth. The courtroom record tells the real story, while Thomas continues to teach the principles that actually work, principles built on mastery, not mimicry. And what makes the situation even clearer is how quickly she shifted her story once the filings didn't go her way. Instead of admitting the mistakes, she created a fantasy version of the case for the internet, hoping no one would read the actual documents. She talked about victories that never happened, orders the judge never issued, and outcomes that directly contradict what is on record. This is how fake gurus operate. When reality doesn't match their claims, they simply invent a new reality. People like her chase the language Thomas uses because they see the results he gets, but they don't understand the work behind it. They want quick money, quick attention, quick authority. They want the illusion of power without the discipline required to use it. They forget that documents don't win cases. Understanding does. 98% of this remedy is knowledge, structure, and expertise. The remaining 2% is the paperwork. And without that 98%, the documents collapse the moment they're tested.
You're rocking with the best. You're rocking with the best.
Bam. Uh-oh. 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 We have finally come to another woo. So, of course, y'all know me. I'm your host, the new coach of Empire. We got a few guests today. We got Darren from the Supreme Elite team. And we have brother Al from the Supreme Elite team. Now, we have a person named Kenyana Stone. Actually, she was just live on, she went live a couple times. She went live quite a few times. And the live was based on the comments I made on her videos, the comments I made on her channel. I sent her the link to this on Facebook Messenger. The comments that I made about her and her teachings. Now, before we get there, I knew nothing about this person. I could care less about this person because remember when I said when you have professionals on your team, that could substantiate everything that you're saying, you don't really care about what anybody else says. So she kept coming across my radar, and this is how she kept coming across my radar. So it started. This is one of them. Bro, do you know of her? You know her or of her? She's from India, my city, but it's like every time you start a topic on something, she's doing the same thing or similar. Now, this is the most recent one. But normally I get that all the time. I mean, I got that with Midwest. I got that with a lot of people who watches me in the clouds, tries to dissect what I'm saying on live, runs back to their groups with brand new talking points. Because, as I've been saying before, and I will continue to say, I am your teacher's teacher.
You're rocking with the best.
And I have not just her, I have people that's been sending me stuff for the past 2.5 years of all the most popular gurus who would say, hey, yo, you said that yesterday. Now they saying this today, but I've been watching their stuff for 2 years and they've never said nothing. But I vividly remember you saying that. Now they switched course. Now they want to talk about accounting. Now they want to talk about securities. Now they want everything is private instruments, negotiable instruments, jurisdiction of the court. It's nothing on the radar to talk about. So this is not a one-off. I've been getting this for multiple, but this one is very particular because a lot of people kept sending me the same things. And I never responded. You know, my response is, well, they better have understanding. You can't just think they're going to run from you just because you bring up some ASC and all that, or just because you can repeat what someone says. You better be able to tie in that with securities law, with court rules and regulations, which is some of the hardest things to do. And this is why you can hear them talk about it, or they can preach about it, but you don't really see them tying it all together, because that's just one major aspect of it. It's not a little aspect, it's a major aspect of it. But they don't know how to translate it into a legal claim. And Kenyana Stone, I gave you the opportunity to come up. I sent you the link privately. I sent you the link on Facebook Messenger. I sent you the link on Facebook Messenger a few minutes ago. You had the opportunity to come up. For whatever reason, you said you was trying to let me come up on your live. You was trying to let me come up on your live, but for whatever reason, I couldn't come up. It said request was, I couldn't come up. So one of the things that I kept getting, and just for transparency purposes, you was allowed, I sent you a link. You did not, you said you wasn't coming on. You said that to your people, you wasn't coming on. And then in your live, and y'all can go back on her Facebook group, it's Kenyana Stone. She added me, the new coach of Empire. She was saying things like, oh, it's a documentary draft. Oh, that's cash. She said, oh, their purchase order is cash. Y'all, remember we've been dissecting those things? The purchase order is cash. Oh, I purchased the home. Remember that? Remember those things? So, and just in case, here's the link. I sent it right to her. That's the link. That's the link to it. That's her link. So I sent her that. So going back to, I kept hearing about her. And then I went on her page and I asked the question months ago. And of course, no answer, because you can cite out all the accounting stuff that you hear other people talk about. See, you can cite that all out. You can cite it out all you want. But being able to cite it and regurgitate it does not mean anything unless you can tie it into a legal claim. And look, she said they stole $200K, but she used a negotiable instrument on check paper like Elliott was doing with the IRS, and they wasn't going for that. They could have said you tried to use a fake check, because that's exactly what she tried to use to purchase the home. Kenyana Stone, with all this so-called accounting knowledge and all this, knows how to go to court and win. She actually lost her case. And as you can see, this is why she did not want to read her whole case out loud in front of her audience. But with the new coach of Empire, we read all the cases. We read all the court filings and the judge's orders.
You're rocking with the best.
So, from the record, and this is what these gurus do, they will tell you about their court case, but they will never actually get into the court case in grave detail. And here is the message I sent to Kenyana Stone back then. Have you ever won a court case using securitization as an argument? Do you know that bringing in securitization in court doesn't help at all, and they usually get thrown out in state court? Further, knowing what took place doesn't matter if you don't fully understand what's going on. Normally, people who go from the sovereign citizen way to accounting all of a sudden seem to just be regurgitating talking points, but they really don't know how to put a federal complaint together. 99% usually fails at the sufficiency stage. They think they can just cite the facts and that's it, or attach a securitization audit to their filings, which is hearsay, and that's all. Under Rule 12b-6, 99.9999999% of securitizations, prove chain of title, trust agreements, etc., get thrown out, especially in state case, especially in the credit card case. This is the time she was talking about securitizations and accounting with credit cards. So I asked her a question. No response. No response. Oh, I'm just laying the foundation. Don't worry, I'm laying the foundation. You know, as court people, before we just jump into it, we got to lay the foundation. Because if you try to just jump out there and question them, they can object. You got to lay a proper legal foundation. This is another person someone sending me a text, asked me, hey, you know Kenyana Stone? Because she was doing all this mixed matching stuff, sovereign citizen stuff. And now all of a sudden, she's talking about accounting. Like, it sounds like she's actually somehow in your class, or someone is giving her your information that you're putting out. Because I don't make up the accounting rules. It's not the accounting rules I'm talking about. It's the methodical breakdown and strategy and understanding behind it is what gets you through the door. You can cite things all you want, but if you don't have full understanding, because the difference between me and Kenyana Stone has not done the thorough research, has not done years of research on this study, nor has she had top elite professionals in this field stamp her. This is all her opinions. But what she didn't want to show you or talk about, and what she tried to lie to her audience and play damage control, was her court case. Remember when I told y'all all these gurus, every time they try to go to court, they fall flat on their faces and then they come back and lie to the audience? Well, we're going to get into that. So this is all from people. This is all from people. I don't know Kenyana Stone at the time, and I really didn't care. I really didn't care. I didn't care about her. But I kept getting messages. Now, all the messages that you've seen, besides the one from Facebook, those were all from people who were sending me messages about her. Now, one of the messages that took the cake, came from somebody that was in my group. Somebody that was in my group. And if you give me a second, this is what I will pull out. So now I was talking to him behind the scenes, and I'm not going to say his name because he's not up here. I'm not going to say his name because he's not up here live. But he said he was in her group before me, and he didn't know a lick about accounting. But all of a sudden, this gentleman that's in my group and her group at the same time is running back, and now all of a sudden, he's giving advice on accounting. And I got eyes and ears everywhere. So one of my eyes, who I got eyes and ears on everywhere for people who's in my group. Because one thing about my group, what goes on in the group is strictly reserved for the group, not another group. Because this is what people will do. People who have no real understanding, they think they really want the position that the teacher's in. They really want that, I guess, whatever they call it. So they really start to naturally envy the information the teacher has that you don't have. And you see a lot of people reaching out, a lot of people want services. People start to envy that. So what they'll do is they'll be in a group as a student, can't tell shit from apple butter, but then they'll go to another group with this new information and start talking like they've been studying, like they've been know what they talk about. And this person got caught because he told me that he was in her group before he discovered me. But if you was in her group before you discovered me, and her history shows that she wasn't talking in great detail about accounting and breaking it down on a professional level, then all of a sudden now you're talking about and you're referencing things, the same thing you was in the group learning. That's a problem. And this is why he was banned. Of course, he say he got remedy, but they all say they get remedy, but they never show any remedy. They never show it. If you go to this, everybody wins, but nobody wants to show. So, in the direct message, which was alarming to me, the direct message was this. This was a direct message that I received from one of my loyal members saying, yo, now look, that right there, with that message he sent, I taught him that. But even still, you still got to be able to break it down in great detail. I taught him that. He didn't know that. He got, you see how people want to be seen, want to be looked at, want your position for real? You see, that was directly after a time I taught in the group. He didn't know that before. Kenyana Stone didn't know that before. Look at all this. Look. Top fan ham. Now he's a guru. And this is what people do. They come into your class, they come into your groups, they do all this shit. They get information they didn't know exists. Now they're a teacher because they secretly want their position. Well, top fan ham, you will never know what I know. Because there's some things that even I wouldn't know unless a top professional in that field proved it, exposed me to it, because it's done internally. It's not made public. It's not made public. You wouldn't know. Let's take the gloves off. You wouldn't know unless I tell you.
You're rocking with the best.
You wouldn't know how to properly hit them with the discovery, the internal documents that they use, unless you worked on that side and you've investigated them. Just like, let's see, an SEC attorney. You wouldn't get an SEC attorney like discovery request unless you actually knew one. Unless you actually had access to one, connections to one. Well, let's move the ex-SEC attorney out the way. Supreme Elite Team Group. Who else do we have access to? An ex-Federal Reserve examiner. Darren, do we have access to that individual?
Absolutely.
An ex-examiner for the IMF. I mean, the World Bank.
Yep.
And that's become the connections one of our group members has to those powerful people in that world.
Absolutely. One call away.
So it's a phone call away. It's literally, if to get what I'm teaching validated by a top professional in the world, it's literally a phone call away. In next class, we'll have the answer. But in your personal thing, Darren, all the phone calls, was there ever any correction from what I'm teaching, or has it been all top validations from the top professionals?
Oh no, they look at us as if we're a colleague. I mean, no complaints, no they don't try to big brother us, or it's like everyday talk. You know what I mean?
Everyday talk. And one of our group members, he said in day one of the master class, he said, yo, you're good. You're in good hands where you're at with that guy. You really don't need me anymore. Yo, you don't got to keep coming to me. You're in good hands. He got it. So all these gurus out here that know accounting, you think you could say the accounting? You have no clue of what it really entails. But let's proceed. Let's proceed. Now, oh, let's see. Let's see if we could. Okay, let's see. Ah, here we go. Here we go. Thank God. Now, I want everybody to stop and share this live because we're about to get into Kenyana Stone's actual case. Because Kenyana Stone was just on her live, which she referenced me. Oh, it's New Culture Empire. She tagged me. She said I was lying. I didn't know what I was talking about. She did win her case. Her case didn't go that way. A lot of her documents were sealed. See, she never showed her court case to her audience. So if you was over there at the Kenyana audience, y'all share this live to your Facebook. Go tag her in the live. Let's talk about Kenyana Stone's case. The case she didn't want her members to see. Because she went and spent the narrative, made a long post. She actually went live 3 times about me. She actually went live 3 times. She actually went live. It ate her up. But before we do that, y'all share the live. 4-7, got a second to share the live. But before we do that, just to let you know how transparent I am, because I really ain't got shit to hide. I show all the good. I show the setbacks. I show everything. I leave nothing out because even if it's a setback on me, it's still a teaching lesson for my students. Your wins, losses, progressions, setbacks are all part of the same game. It's actually still a teaching lesson because if we could dissect, okay, this didn't go as planned for me. Let's dissect, let's break this down. Now my students got foresight on potential roadblocks and they can sidestep them before. So let's talk. This is the text I sent to Kenyana Stone. How you teaching accounting when you were just filing sovereign citizen claims? You created a check with your SSN as the account number and the FRB as the routing number. Why didn't you wire the money out of your own bank account? There is no secret trust fund, but since you know accounting, show a receipt where they stopped collecting from the docs you sent to the finance company's compliance department. I can.
Absolutely.
I can. What is it? July, August, September, October, November, December. I can show. Actually, y'all already seen it. I have receipts. I have cases where the judge didn't throw it out. We can debate live in front of our audience about accounting. I am your teacher's teacher. And actually, I was in court yesterday where I had the video where not only did I file my motion to set aside judgment way past the statutory time frame, the judge overruled her argument to throw the case out. Oh, I have that live in court. Huh? Wait, where these gurus recording themselves in court in real time? But we'll get into that. Someone from my class was giving you information. I found out. Thank God the SEC attorney gave me information that you can only get from those on the side. So without that, y'all will still never get it. Right? That's the first message I sent to her. Kenyana Stone last night when she said, well, you could have called me, text me. I did. You never responded. Hold on. And to top it off the message that I sent, see, I just don't make vague accusations. You know what I did with the message? Along with the message, I'm going to tell you what I attached to the message. Look at this. So just because I wasn't just blasting her, I sent her own case documents. You see the files? So she knew what I was talking about. But she went on live today and lied to her audience. See, this is what her audience don't see. Look. So I sent her the message along with what I was referencing. And let's just see. Let's just see. Let's just see. Hold on. Let me share this other one. Okay. So let's just see if she actually responded back. Let's just see if she responded back. All right. Let me move this out the way. As you can see, nothing. The same documents. You see that? Nothing. Because they all, when the Grim Reaper comes out. I am the Grim Reaper of these gurus. They ain't been comfortable since I hit the scene. Because I was getting results before I even came to YouTube. That was the biggest difference between me and them. I was already getting results before I started teaching. Because I was behind the scenes. And I watched this space for 2 years go up in flames. Let's get to it, y'all.
You're rocking with the best.
Yes, sir.
We about to get to it. I want y'all to reshare this. Because her people are going to see what she did not want to show. Any of y'all got a YouTube channel? I guess y'all can I guess y'all can restream it to your audience. I don't know if any of y'all can restream it to your audience. If you can restream it to your audience. But we are about to get into it. We are about to get into it right now. Give me a 15-second intermission. I already got the cases pulled up. We're going to break down the case that Kenyana Stone did not want her audience to see because she lied and spent the narrative. No, it didn't say that. Well, I have the actual words, and I'm only going to go by the actual words, not your interpretation of it, because you're talking to someone that knows how to interpret case law, that knows how to read case law and interpret it. Give me 15 seconds, and we are in it.
No pressure, nah, I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top shit, I'ma let her. With this street code, I abide to the letter. It's just me against me, I ain't feeling no pressure. There's no hoes barred with the shit, nigga, everything gon' go. Hoes come to see me, I miss a heart and hustle up with the flow. I used to stand in the crowd, but now I'm the star of the show. My 10 in the field of play, I know you niggas looking down at my toes. I'm only smoking, no pressure. I'm digging graves with the shovel. Just like Pac in my nigga bags, you should know nigga being rubber. They watch the corner for a stat. Watch out, my little nigga be the lookout. You broke that shit.
You're rocking with the best.
No pressure, nah, I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top shit, I'ma let her. With this street code, I abide to the letter. It's just me against me, I ain't feeling no pressure. There's no hoes barred with the shit, nigga, everything gon' go. Hoes come to see me, I miss a heart and hustle up with the flow. I used to stand in the crowd, but now I'm the star of the show. My 10 in the field of play, I know you niggas looking down at my toes. I'm only smoking, no pressure. I'm digging graves with the shovel. Just like Pac in my nigga bags, you should know Liddy be a rebel. They watch the corner for a stat. Watch out, my little nigga be the lookout. You broke that shit embarrassing. Like the drunk uncle watch the cookout. My 10 down, you got a foot out. I fuck my bitch, never pull out. A bitch drowning my drip flicker, she gon' feel the stain from my wrist. you disrespect on that click. I put the tech on your lips. No handouts, they gon' go get it lit. Cut a check for a quick. No pressure, nah. I ain't feeling no pressure. No, I ain't stunting her, man. She wanna get on top shit. I'ma let her. Come here. With this street code, I abide by to the letter. 100, nigga. It's just me.
Let's go. Let's go. I don't need to add you anymore. I made that my point. Let's go. Let's share this motherfucker. Let's share it. Here we go. Kenyana Stone. This is public record. Public record. Now, this case, and I'm gonna see if I can zoom in, but I don't think. Okay, I'll make it lighter for y'all too, but I don't think I can zoom in because it's on the browser. I will zoom in for y'all, but that's the most I could do. So you might want to pinch your screen if you can. So this case started in. Hold on. Let's go. Yeah. Let's go back to the beginning. So this case started in December 4th, 2023. December 4th, 2023. And she was telling me she knows about cash. You don't know what cash is. Documentary draft is cash. Okay. So Kenyana Stone, this is an appearance file. Okay, so it looks like, hold on. It looks like they're making me. Okay, I see what. All right, I see what they're doing. I see what they're doing. So what I'm going to do is I'm going to go down and guess what? Complaint. This is what I'm going to do. I'm just going to go here and I'm going to download all this. Motion for, I'm going to download all this, y'all. Look, this is her whole case. And this is her subpoena. Look, this is her subpoena. Notice of exclusion of confidential information. Order set for hearing. And here's the order. Okay. We don't need to see the order for hearing. We don't need a service return. Here's the answer. We're going to walk it all down. Witness exhibit list. We don't need the witness exhibit list. Oh, document file, plea of tender. I bet she had accounting with that. Okay. Motion for enlargement for her respond to sign. And they granted. That's basically saying, yo, hurry up and respond. There's the answer, January 31st, 2024. Here's her counterclaim filed. Witness, we don't need the witness list. Here's the counterclaim and witness. Here's the counterclaim filed. Yep. Motion for summary judgment. Memorandum in brief. Evidence in support of summary judgment. Let's get all that. Designation of evidence. Order granting summary judgment, which Kenyana Stone, I think she said. Now look at all this. Motion filed. Counterclaim. Motion to reconsider. Order denying motion. Motion to reconsider filed by Kenyana Stone. Order denying motion to reconsider. Defendant's motion to reconsider summary judgment. And order denying it on November 20th. Now she got administrative event. Okay. Administrative event. Clerk administrator. Notice of appeal received. We're not going to. Only things I'm not downloading is stuff that really it doesn't matter. It's just, you know, appearances and all that. Motion filed. Order. Why didn't you go down all of this with your order received? Bam. Now, there we go. All right. Okay. So I'm gonna stop sharing. I'm gonna come back here and we're gonna pull it up. We're gonna pull it up. We're gonna pull it up one by one. We're going to start with everything that we just did. Get to the downloads. Hold on, let me download. Let me go to the recent. You know, one thing that I really hate about this MacBook, when they download it, they have them so scattered all over. They have them so scattered over. Okay, so here we go. Full download history. All right, I got it right here. I got it right here. All right, here we go. Appearances, Exhibit A. Let me. All right, so here, I got it. We can do it like this, y'all. I'm sorry, we can do it like this. I'm going to share my screen again. We can do it like this. We can do it like this. We're going to do download history, share screen. Okay. Appearance file, Exhibit A, Exhibit B. Let's get to the complaint first. Then we can get to the exhibits. Get to the complaint first, and we can get back to the exhibits. So, Kenyana Stone was attempting to purchase a house for cash. I think the asking price was $1.7 million. And what Kenyana Stone did was she tendered payment. And then she tendered payment, but they never credit the money to the account. The seller, Kimberly Short, under the Kimberly Short Trust, actually canceled the transaction through their attorney. And Kenyana Stone saying, number one, you can't have a de novo hearing. Number two, they stole the money. Number three, the judge says the security was good and all this, so she's going to win. Okay. The complaint reads, Plaintiff's Trademark Inc., Kimberly Short, and Kimberly Short as trustee under the Kimberly Short Declaration of Trust dated May 6, 2003. Trademark Short, those are the plaintiffs. By counsel, allege and state their complaint against Kenyana Stone and Kenyana Stone as trustee of the Kenyana Stone Revocable Living Trust. Stone and the Revocable Living Trust are the defendants. Okay. At all times, relevant hearing, Trademark Title Inc. was a corporation organized and existing under the laws of the state of Indiana with its principal place of business in Indiana. At all relevant times, Kimberly Short was a resident of Marion County, Indiana. So they're just establishing a jurisdiction for the court. On or about June 20th, 2023. So this should have been the time that she was a master of accounting. But according to the emails I got, she wasn't on this. I'm talking about there's a difference between being on it in a professional manner and being on it based on some stuff you're regurgitating. Defendant executed a purchase agreement because on her live, she said the purchase agreement was cash, you dummy. Y'all remember the purchase agreement, the purchase order and all that? Right. And she said the CEO of the title company told her. They always tell you about these professionals that tell them what they're doing is good, but them professionals, it never plays out the way the professional said. My case is playing out the way the professional said it would. So they always think these professionals they're talking to. Wherein defendant agreed to purchase from Short real estate and improvements located at 5710 Brookwood Road. A true and accurate copy of the purchase agreement is attached in Exhibit A, and we'll get to that. The agreed purchase price for the real estate was $1,700,000. Remember when I told y'all? There's some secret trust, use an instrument, and it's always going to be $1 million homes. It can be a modest $200,000, $300,000 home. What is this the hallmarks of? Already a sovereign citizen, low-hanging fruit teacher, poverty mindset, desperate for the shit that she couldn't just go pay or wire in real life. With payment to be made in cash. Y'all see where this is going? With no finance required.
That's crazy.
You see where it's going? Do y'all see where it's
Absolutely.
going? It's already going down that path. I can already see where this is going. Payment to be made in cash. You know what cash is? You get a cashier's check out of the account where your money, when you got access to every day, is in, or a wire transfer, which is like 24 to 48 hours. So we already know where this is going. Defendant, as means of providing the purchase price for the real estate, mailed to Bank United Trademarks Bank a check made payable to the United States Treasury. A copy of the check is attached at Exhibit B. So you sent the check that was made payable to the United States Treasury to Trademark as payment for the home. Ladies and gentlemen, if you had $1.7 million and you wrote a check and the 1.7 is sitting in your account, who would be the payee on the check? The title company, yes. But when you don't have real legitimate $1.7 million, what is the next step in the ideology? What's going to come to mind? Oh, there's a secret account with 1.7 million in it. I'll send it to them. Y'all send it to them. They'll send you the money. Y'all see where this is going? So while she was online lying, saying it wasn't a sovereign citizen process, when we look at the words and break it down, you can actually start to paint a picture. This is not my belief. This was based on the facts. I can build a narrative based on facts. The check remitted by defendant was drawn on Trademark's own bank account, not on defendant's bank account. See what I'm saying? See what I'm saying? Remember the scenario I just gave? I told y'all this shit is too easy. They could go on. She went on live 3 times about me. They can do the hoopla all they want, but I'm always going to pull the cloak off them because I understand how the system works. Normal, common logic. It will, if you stick to those, just decent, normal logic, what happens in everyday life, you will pull apart their shenanigans. Was signed by defendant and was made payable to the United States Treasury. After sending the check to Trademark's bank, defendant requested that the bank wire funds to Trademark, which request was refused as defendant had provided no funds for which to wire, and thus no funds were received as payments of the purchase price under the purchase agreement. Kenyana Stone, didn't you say that you already paid the house off in your life and they stole it from you? I mean, I was like, nah, they canceled it because the money never came. And she was like, what are you talking about? The money did come, it was sitting there as a credit, you dummy. Okay. On or about, now from July 5th. Hold on. Let's stop. We're going to go to number 11. As a result of defendant's failure. Oh, hold on. We got someone in the building. Okay. We got you. We back. We back. We going to walk it down. As a result of defendant's failure to pay the purchase price for the real estate, the transaction failed to close by July 5th, 2023. Deadline for closing, and said deadline was not extended by mutual agreement of the parties to the purchase agreement. So this was July 5th. On or about October 10th, 2023, defendant recorded a UCC finance statement with the recorder of Marion County, Indiana, under instrument number, listing plaintiffs as debtors and listing the trust as a secured party, the finance statement. So she tried to claim the house as yours. What are the people that normally do this when they have no legal basis of doing it. Sovereign citizens, because remember, they own the house when they believe they own the house. They don't own the house once you close like normal people do. And you close, you sign, you get the keys, you get this title, you get all that from the attorney. They expect it, everything's good. No. They own the house when they believe they own the house. That is sovereign citizen. Who else did something like this and went to prison? Christopher Hauser, filing fraudulent liens. Hold on, go back up. Oh, I gotta go back up. Oh, I gotta go all the way back up. Right here. Hold on, why is it doing this? Oh, I gotta go up manually. Okay.
So she just goes around stealing different packages, huh?
I don't know what she does. She would have never came across my timeline because people just kept sending me stuff. Hey, yo, she keeps saying the same thing you saying, but I was in her group and she was never talking like this. She don't know this. She just regurgitating shit. And I was, and before I responded, I was like, I finally addressed her. I was like, well, you know how that go. They better have understanding. But then I just kept hearing it. So I said, let me address this. What threw me off is, y'all, we just finished up day 2 of the masterclass, and once $99 securitization masterclass. But when I go over her timeline, she's never consistent in her processes. She's all over the place. She's doing this and doing that, doing this. And the people and the teachers that are normally inconsistent and always got a new method of doing something, those are the people who never did the true research that people are believing that they did, and they have no foundation. The finance statement also asserts that debtors are transmitting utilities. What is a term that sovereign citizens use to file a UCC1 over their all caps? They say the all caps is a transmitting utility. And she admitted on live that being a sovereign citizen ain't bad. So I know she carries those ideologies. So having a sovereign citizen ideology while trying to employ accounting is the thing that they all do, and it's a virtual, legal, deadly cocktail. It makes a vague description of the collateral, encompassing a wide array of assets, but does not specify which alleged debtors' assets are collateral. But I guess she knows how to fill out a UCC1 correctly. The finances statement also makes reference to the description of collateral to an instrument identified by the number, which corresponds with the check number on the check attached as Exhibit B. That's crazy. The finances statement also states in Section 6A that the transaction is a public finance transaction. That does that, a public finance transaction for me, and I'm not going to look at the screen, that only applies to like public utilities, like the water companies and electric companies, not what she's trying to do. But who advocates for using that term? Sovereign citizens. Yes, y'all following along. States that in Section B that the filing applies to the agricultural lien. Who started that? It with the sovereigns, Gene Keating and them. You got to file it as an agricultural lien. These are all early 2000s UCC1 filing methods that she's employing in 2023. And states in Section 14 that the finance statement is filed as a fixture file. All these are the same things that they've been telling people to file UCC1 on their all caps since 1998. In Section 15 of the finance statement, defendant identifies the trust created by defendant Stone as the record owner of the real estate. Plaintiffs never granted defendant any security interest in any collateral. But I get it. They all think that a UCC1 doesn't have to really be authenticated by the debtor, meaning the debtor doesn't have to agree to it. The debtor's in debt when they believe the debtor's in debt. The mindset of a sovereign citizen, yes. Plaintiffs never enter into any security agreement with the defendant where there's a legal known obligation of debt legally. Plaintiffs never authorize the filing of the finance statement by defendant because they all think that if they believe they can do it, they'll just do it, regardless if it's not legal or valid. Remember, with us, it's all about the facts, procedure, rules, laws, stand within the confines of the regulations they set. With people like Kenyana Stone, it's beliefs, ideologies, theories, and then they'll move from that. Even if it contradicts or is in conflict with the real rules. So when you follow people like Kenyana Stone, based on that mindset, the ideologies, and the meanings and the reasonings with this one document, everything that she's going to tell you to do, you're going to be dead on arrival, because the only thing you're doing is taking her mindset and belief system and imposing it in your documents, which will be dead on arrival. Plaintiffs never incurred any debt in favor of defendant. Plaintiffs incorporate by reference the allegations contained in paragraph 1 through 21. Defendant is not a person entitled to file a UCC finance statements against plaintiffs under Indiana Code 26.1.9, 26-1-9.1-509. But I thought she would have read that code before she attempted to file it so she could know the rules and can she legally do it. Plaintiff has been damaged by the defendant's unauthorized recording of the financial statement. By virtue of defendant's unauthorized record of the finance statement, plaintiffs are entitled to recover damage, both actual and statutory, from the defendant under Indiana Code. Plaintiffs are entitled to recover reasonable attorney's fees and reasonable legal expenses from the defendant under the code. Wherefore, plaintiff respectfully requests judgment in favor of plaintiffs and against defendant for actual and statutory damages to be provided by the evidence, together with reasonably attorney's fees and reasonable legal expenses, interest, and costs, and for all other relief just and proper in the premises. But I'm pretty sure that she would know how to set that off. She knows accounting. Plaintiffs incorporates by reference the allegation, paragraph 1 through 26. The presence of the unauthorized finance statement in the public filing caused harm to plaintiff by misleading potential purchasers of the real estate and lenders of potential purchasers of the real estate. Plaintiff hereby demands that defendant file a termination statement with the Marion County's Recorder's Office in accordance with the Indiana Code. Additionally, plaintiffs request that the court enter an order declaring that the financing statement is invalid and no legal effect. But Kenyana Stone, didn't you say on your live that it was legit? Didn't you say it was legit? And this is the reason why I say what I say. They will disregard the real rules to the game if it doesn't comport with a method that they believe. They move off misinterpretations, misunderstandings, lack of context. And if the courts or the attorneys or the system gives a different view, says, no, this is not legally right. This is not legally right. They will disregard that and tell the people we're going to keep fighting. This is what I mean. Shout out to Tahir. Shout out to Tahir for the 40 ball.
You're rocking with the best.
Shout out to Tahir for the 40 ball. We appreciate you.
You're rocking with the best.
Shout out to you. If you like what you're in, and if you're feeling generous, you can go ahead and donate to the CA, to the cash out right there. But I'm not really exposing Kenyana Stone in the grand scheme of things. I'm not exposing her. All I'm doing is just reporting exactly what she filed in the response. This is all I'm doing. Requiring plaintiff, we'll move it to number 2. Requiring the Marion County Recorder's Office to remove the finance statement from the public records of the Office of Recorders of Marion County. Wherefore, plaintiff respectfully requests that the court enter an order declaring the financing statement is invalid and no legal effect, removing the financing statement from the public records of the recorder, and granting all of the relief. Request for quiet title. I'm going to move down to 32 because they're just saying the same thing in 31. The short trust is the record owner of the real estate, which is more particularly described in Exhibit D. Defendant fraudulently recorded a UCC financing statement asserting a security interest in the real estate. But when I say she filed the UCC statement fraudulently on her live, she nearly jumped out at the screen saying it wasn't fraud. So you got me and a licensed attorney saying it's fraud under the statute. But this is the mindset of most people. They are so far gone in their illusions and their beliefs, which are based in no law of fact, that they will ignore any evidence or information that does not comport to their belief system. Kenyana Stone is no different. Kenyana Stone would never survive in my world because she has sovereign citizen roots, and it comes up in cases and instances when their backs are against the wall. When your back is against the wall, your real foundation is going to come out. And that's the sovereign citizen for 98.99% of people in these spaces. Number 34, pursuant to IC, that's the code right there. Short and the short trusts are entitled to quiet title in real estate. Wherefore, short and the short trust respectfully request that this court enter an order quieting the title on the real estate described in Exhibit D, stating that short trust legal titles is superior to the right and interest as may be claimed by the defendants, holding that defendants have no right, title, or interest in the real estate, and granting all other just and proper relief. Injunctive relief. Plaintiffs short and short trust possess ownership of the real estate. Defendants have slandered short and short's title to the real estate. But didn't you just hold a master accounting class? See, this is really more for short's audience, because I'm going to post this and chop it up and just clip it up and post it all on social media. But one thing you cannot say is that I'm lying or I don't know what I'm reading. And this is why they never want y'all to see their court cases. Short and a short trust have a pending sale of the real estate that is at risk of falling apart if defendant's recording of the financing statement is not resolved quickly. So when I say they already sold that home, you're like, no, they didn't. Still in court. I'm still in court. I'm about to win. She called me a liar. I didn't know what I was talking about when I said, yo, I read the record. They already sold the home. But she's going to still lead y'all to believe that the case is still ongoing. That is still ongoing and she has a shot. You see what I'm saying? They've already sold that home. It's over if there's a new owner. And she knows it's quiet on her end. But she will come on live. Like, she go watch her live on her channel. She may take it down. She's definitely going to take it down after this. And if Kenyana Stone, timestamp 314, Kenyana Stone, Kenyana Stone, if you take those lives down when you was commenting back and forth with me, if you take them down after this here and you take them down, it means that I was right and you was wrong, and you don't want your students to know. You're going to take those lives down, I guarantee you, because you said I was lying. I didn't know what I was talking about. But right here, this is what actually happened in your case. That's one thing about being a teacher. You got to take the good, the bad, the ugly. You got to be able to stand under scrutiny. If not, stop teaching. Therefore, short and the short trust will be irreparably harmed if defendant is not enjoined from asserting a right, title, and interest in the real estate by virtue of the finance statement. The public interest is best served by granting the injunction, as the public has an interest in recognizing and enforcing valid property interest. The public has a right and right. What I'm doing is it's all within law. This is public, all within law. Under Indiana law, this court has the authority, if it determines that defendant obstructed or interfered with the short and the short trust ownership of the real estate, to enjoin defendant from further obstructing and award damages resulting from the interference. And they request the order to enjoin defendant from asserting in right, title to the real estate, directing Marion County Recorder to remove the finances statement from its records related to the real estate, and join defendant from taking further action obstructing or interfering with short's right, title, and interest to the real estate, and granting all other relief. And this was submitted by Eric Glasgow, counsel for plaintiffs, attorney number. As a matter of fact, everybody, stay by right quick. Stand by. Stand by. Don't go nowhere. This should be a very interesting live today.
Thank you. Stevenson Rice, may I help you?
Yes. Can I speak to Mr. Eric Glasgow?
He's in a meeting. Would you like his voicemail?
Yes, but I mean, I don't know if you can answer, but I'm checking the public records in the case that he recognized, and I don't want to take too much of your time. There was a case regarding Kenyana Stone in short trust, and I would like to know, based on the public records, is that home, was the quiet title off the property and subject lifted?
Oh gosh, I don't.
You don't know? Okay, I get his voicemail. All right, I get his voicemail. That's okay.
Okay. Thanks. Just a moment.
All right.
Eric Glasgow with Stevenson Rice. I'm either on a call or away from my desk right now. Please leave your name, number, and a brief message, and I'll get back to you at my earliest convenience. Thank you.
At the tone, please record your message. When you have finished recording, simply hang up or press pound for further options.
Hey, Mr. Eric Glasgow, my name is Lamont Thomas, and I'm calling because I've seen the public case and the public records regarding the Stones, Sharon Stone. Well, let me get the right name for you. The Stone Trust and defendant Kenyana Stone. And I was calling to see if Miss Stone, Kenyana Stone, still remained a valid legal title and rights to the home, or were the cases shut down? Because I actually appreciate you all filing this, because there's so many people that are trying these scams out here today. So I'm a reporter, and I'm trying to bring awareness to the public. So if you can give me a call back at let's see if the attorney will call me back. I told you, boy. I told you. If that attorney calls me back, I mean, I already know what happened, but if he calls me back, shit. Okay. Now, let's get to the exhibits. So, this was the purchase agreement. And this agreement looks like a typical standard purchase agreement. And the purchase price is $1.7 million to be paid for in US dollars. There was no earnest money, so she didn't have to make a down payment. She would have never got that far. She would have had to make an earnest money deposit. She wouldn't even got that far. And the method of payment, cash. See that? Number one, the method of payment was cash. So the method of payment was cash. That's all I need to see. One second. It was going on. It was going on Bob live right now on YouTube. I got the scalpel. I got another guru in surgery right now.
Okay. Call me back because I got something very important to tell you.
Oh, I know. Hey Troy, one thing about it, man, we are connected. Boy, thank you so much, big brother.
Yeah, I got you something that's gonna smoke you. I mean, you're gonna love it. All right.
Oh, I will call you back as soon as I'm done.
All right, man.
All right. Bye. Oh, remember we was talking about a member that's connected to all the top professionals in the world with this shit?
You're rocking with the best.
Old white people, they just take a liking into this. Old white people brought me in their circle. They brought me in their circle. With all my imperfections, I'm still in the midst of their circles. Hey, New Culture Empire. I don't know what's wrong. Dan, you come back up. All right, let's get back to it. Okay, so that is. Now here's B. This is the check. $1,736,130. She said a documentary draft. A documentary draft does not come in check form. It's a actual draft with shipping documents and the goods to be paid for attached to it. Documentary drafts are usually used in like international shipment transactions. But this was a check that she created payable to the United States Treasury for credit to Trademark Title Inc. Well, if the money was actually coming out of your bank account, why would you need it to be payable to the Treasury and credit it to their account? Like the Treasury is going to take that check, go into some account that you may have rights in, and pay them. That's the only way you would do it. And only way you would think you would do this if you believe there's some type of interest or rights in an account at the Treasury or with your name on it that you can draw down to make large purchases and pay your debts. But let's go a little further. Because I believe they've always put notices about this out. Huh? I believe they always put notices on this out. They always put notices on this out. Drawing checks on the U.S. Treasury, because this is nothing. This is an old sovereign citizen scam. Huh? 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 A stripped down version of this scheme is as follows. When the United States went off the gold standard in 1933, the federal government somehow went bankrupt. With the help of the Federal Reserve, the government converted the bodies of their citizens into capital value, supposedly by trading birth certificates of U.S. citizens on the open market. After following a complicated process of filing UCC documents with either the Secretary of State of the person's residence or another state that will accept the filings, each citizen is entitled to redeem his or her value by filling out a site draft. It's payable on site. A site draft. Oh, yeah. Filling out a site draft drawn on their non-existent Treasury Direct account. This scheme asserts that each citizen's social security number is also his or her account number. As part of the scheme, participants file false forms. The reality, drawing such drafts on the U.S. Treasury is fraudulent in violation of federal law. The theory behind their use is bogus and incomprehensible. The Justice Department is vigorously prosecuting these crimes. Federal criminal convictions have occurred in several cases. The arms show the current comptroller of the currency has tried to alert the banking committee of this fraud. It has been brought to our attention that certain individuals have been making and executing worthless paper documents, which are titled site drafts, or it's basically a check payable on site. In other words, these items state that they are payable through the U.S. Treasury. Well, hold on. Something just caught my attention. Didn't this item state that it's payable to the U.S. Treasury? Ain't that what she said? It's payable through the U.S. Treasury?
You're rocking with the best.
Ain't that what she just said? It's payable to the U.S. Treasury. These instruments are being presented for payment at banks and other businesses throughout the United States. They have no financial value and have no legal validity. Documents follow the characteristics. A statement printed on the items, the numbers encoded in the MCR style print along the bottom are not valid ABA routing numbers or any recognizable type of number used in the financial community to process or identify the item. The person signing the document is not authorized by the U.S. Treasury to issue such documents. Any of these instruments that are presented to the U.S. Treasury for payment will be returned to the sender, and copies will be provided to the appropriate law enforcement. If one of these instruments presented to your institution, send it to your Office of the Comptroller, Enforcement and Compliance Division. Now, what they're talking about is, since this is around the time in the beginning, since they were doing it so much, give me 1 second. All right, give me a second. We about to get back to it. Give me one second. It's about to get better.
Run it up. Hey, I'm cooking up dog food. Yeah, she play with the dick with the tosses. Wow, smoking that leaf from Toronto. They watching that whisk like a car show. You look like you wanna get shit off your chest. What's up? I thought so. Okay, I'm back in this game. Now you sit at the end of the bench. What's up? I thought so. Okay, yeah, back in this motherfucker like a left something in this bitch. A whole gallon of the white. I'm getting drunker than a bitch. Big straps with the Mac 11s got me putting extendos in the clip. And lay your shit up on the curb. Like you didn't pay your rent. Okay. Got Papa John dope, but no pizza. The dope with a flipping straight O's and the zippers. Right off the Peter Pan, intake at 9 if you open this millicent with you. My BBE label with guys on the table. Fuck your Scott and your Dracos. This map make you jump, no Chris Carson.
Yeah.
You get Scott like potatoes.
All right, let's get back to it. Let's get back to it. Yeah. All right. So as you can see there, Exhibit C. Right here. Requirements. So you list down the requirements. This is what that's part of their exhibits. Let's get to Exhibit D. All right, that it's insignificant, y'all. It's not saying. I'll show it to you. It ain't really saying shit. I don't want to be like, see. Don't want to show that. All right, so we about to get to the motion for temporary restraining order. This is Kenyana Stone now, the guru. So we already established the fact that she tried to pay for a house, writing a check on the Treasury based on a false belief that there's some secret funds. She didn't have the money to pay for out of her own account. That's evident. So she tried to write the check, send it to title, payable through the Treasury, and the Treasury is going to credit their account. The lawyer said no such funds ever sent and nothing never happened. So they canceled it. Canceled the transaction. with her sovereign citizen beliefs and got to save face. Now she gonna go try to put a lien and title on the house. Well, the judge said it. The judge ain't say that. See, they all misinterpret what they think the judge says and what the court says in their rulings. They never fully understand what's being read or understood because they don't know how to speak legal words and legal terms. Legal terms have their own distinct meanings, but her understanding doesn't go as far as she thinks it does. And this is why she said, I don't got to show my court case to it. That's just everything that's found. It don't show everything because a lot of my documents were sealed. Okay. We will see if let's see if your motion to seal your documents were granted. Let's just see. Comes down to plaintiffs, which is trademark title, and Kimberly Short, a trustee, in the Short and Trust collectively and move the court to issue a temporary restraining order followed by a preliminary injunction after a hearing, precluding the Kenyana Stone, both individually and as trustee of the Kenyana Stone Revocable Trust, from taking any action or asserting any right, title, or interest in the real estate by virtue of the financing statement recorded in Marion County. And in support, will show the court the following. On or about June 20th, 2023, Short and defendant executed a purchase agreement where defendant agreed to purchase from Short the real estate and improvements located, bam. A true accurate copy of the purchase agreement is attached to Exhibit A, as we see. So basically, when she went into the transaction, she was trying to scheme. She never went to the transaction. Yeah, I got 1.7 million to spend on a house. She went and trying to do a process. That's why I've been studying. Yeah, and you still ain't got it right. Defendant at means of providing for the purchase for real estate, mail Bank United, Trademarks Bank, a check made payable to the United States Treasury, which we have already seen. United States Treasury. A copy of the check is attached to Exhibit B. The check remitted by defendant was drawn on Trademark Bank's own account and not defendant's bank account. So that check the check was, the account number for this check was either her social security number or Trademark Bank's account. Even worse. It'd have been better off for just to have her own social security number. I'm not advocating it still ain't gonna work, but it looks even worse by you trying to use their own account number. It looks even worse for you. It looks even worse. The check remitted by defendant was drawn on Trademark Bank's own account, not on defendant's bank account. It was signed by defendant. It was made payable to the United States Treasury. After sending the check to the Trademarks Bank, defendant requested that the bank wire funds to Trademarks, which request was refused as defendant had provided no funds for which to wire. So when you're dealing with these companies buying purchases, real estate, they're not going for none of that sovereign citizen slickeroo, all cash money. That's it. All cash money. That's all that. Here's the document. It's the equivalent. Cash money. Either a pre-approval letter or you got a fucking certified bank check signed by the bank's manager. That's it. And if you ain't got the cash money to make the purchasing, now you got to go get a mortgage. But if she knew so much about accounting, why did she just get the mortgage and work her accounting tricks? Why did she just get the mortgage, work her accounting, and get the satisfaction of lien? Because none of them can. Thus, no funds were received as payment of the purchase price under the purchase agreement. So this goes by the same things we just read. In this document, it's all the same thing. Never authorized the filing, all this. It's all the same thing we just read in the complaint. So, once again, Kimberly Short signs it, bam, right? Okay, so that's the motion for temporary. So this right here is the summons. You have been sued by, so the summons was issued because the plaintiffs, the attorney, they passed the initial sufficiency stage. And based on the face of the complaint, it appears that they have stated a claim. So now it's Kenyana's turn to respond. Oh, we got to pause for a second because I need everybody to share this one more time. We're getting to Kenyana Stone's own words. Let's get it.
You're rocking with the best.
Kenyana Stone, we are getting into your own words now. These are the words that you stated. Now, I'm not making it up. Now we get it. Let's go. Let's go. Let's go. Let's share right quick.
I'm cooking up dog food. She play with the dick with the tosses. Smoking that leaf from Toronto. They watching that waist like a car show. You know like share. Off your chest. I thought so. I'm back in this game now. You sit at the end of the bench. I thought so. Yeah, back in this motherfucker like I left something in this bitch. A whole gallon of the white. I'm getting drunker than a bitch. Big straps with the Mac 11s got me putting extendos in the clip. And lay your shit up on the curb. Like you didn't pay your rent. Got Papa John dope, but no pizza. The dope with his flipping straight O's and the zippers. Right off the Peter Pan, intake at 9 if you open this millicent with you. My BBE label with guys on the tables. Fuck your squad and your Dracos. This map make you jump, no kiss cost in the stable. You can scout like potatoes. Shorty saying that I am the one lady. Who the fuck you think she Billie Jean? She want a nigga, put her on the team. After spitting out my kiss, a Listerine. The flow is bucking like it's Greek the Freak. But I keep it 44 like Pistol P. Now really shitting on your biggest dreams. About the floor with you niggas, Mr. Clean. I'm cooking up dog food. She play with the dick with the tossers. I'm smoking that leaf from Toronto. They watching that waist like a car show. You look like you wanna get shit off your chest. I thought so. I'm back in this game now. You sit at the end of the bench. I'm in the projects like I'm packed with a cake. They ask about it, they say missing no plate. I know the smells when they pull out them trays. It's nothing edible that sits in the place. Right out of prison, I ain't snitching nobody. You ain't jumping lessons up on the base. I need some wild so I can splash in the lake. And I need a rat so I can eat. I'm a snake. My bitch from Louisiana and she Creole with sticking head. Hop and knowledge she clear. We ain't missing, ain't no shots at the feet though. The out of time got them thinking it's zero. Sticks be as long as a cord extender. You get blown like a cartridge Nintendo. Fuck nigga, X you out like you nothing. That's because you be praying the middle. I got an issue with the streets, it's breeding snitches. That's why I'm a family guy like Peter Griffin. Heard about Western Road, think I need a Smith. And issue time with his close, I think he a blister. Matters with the clips, I'm pushing T in my sack. You want the smoke, and you'll get your T at your nap. Alphabet sticks, let the T in the map. Bitch, I'm hotter than few, that's gonna leak out the jet. I'm cooking up dog food.
And let's, Miss Kenyana Stone, let's not get it twisted. I don't live that type of life anymore. But let's not get one thing. Let's not get one thing twisted, Kenyana Stone. You or a lot of people that you may know, I swear, if I was still living that life, if I was still the old me, I swear there'd be a lot of thinking twice. I'm not even a tough guy anymore. I don't live that life anymore. Now, if we got to go there, we can go there. But this, when the feds had to come get me, I was kicking up so much dust. The feds had to come get me. The federal government had to come get me. It wasn't because I stole bubble gum. Let's not get it twisted. Let's not get it twisted. So let's get back to it. Now, let me go back to sharing my screen. You already shared. Okay, so this is the summons. Motion, summons to them. Okay, so give me 1 second. We're going to read this because this is next up on the list. I swear to God, Ms. Stone, you or everybody you know wouldn't have been able to survive the maximum United States penitentiaries I was in. Half you people out here wouldn't have been able to survive. Because there ain't no guarantee you're gonna come home alive in the penitentiaries. You're gonna be a man in there. You're gonna be a man in there. And ain't no guns where you can shoot 5,000 feet away and spin the block. Now you're gonna be a man. You're gonna settle your. This how problems get settled in men. You're gonna squab it out. Or dude gonna come in your cell, hand you a knife, and say, "Let's get it." He gonna bring you one. Let's go. I'm ready to work. Here, put it on. Let's go. What you gonna do then? Ain't never been in that predicament before. All on knife fight in a room this big. Ain't ready. Contemporaneous with the filing of this notice, Plaintiff's Trademark Title Inc., Kimberly F. Short, and Kimberly K. Short as trustee by counsel have filed confidential information under Indiana rules of access to the court. To provide notice that the confidential information to remain excluded from public access, according with the bank's account number and bank account and social security or personal identifier number. So all that's been excluded from the record. Cool. Now, let's get here to the order. Now, this is the order. I'm just going by in order of how I typed it. This is the order. This cause having come before the court on plaintiff's verified complaint petition for temporary restraining order, and the courts having reviewed the verified petition and appearing that unless the defendant is restrained from taking any action or asserting any right, title, or interest in the real estate, the plaintiffs will suffer irreparable harm. Plaintiff's verified petitioner is plaintiff's verified petitioner is hereby granted.
You're rocking with the best.
So they granted the petition against you. They granted the restraining order against you. You said the restraining order was against them. This is now you see why she had to go live 3 times. It was eating her up. She's like, damn, he caught me. I got to go spin this narrative. It is hereby ordered that defendant and her agents, successors, assigns, attorneys, and persons acting in concert with them shall immediately take in any action or asserting any right, title, or interest in the real estate at the location, Indiana, such that it prevents plaintiff Kimberly Short from completing the sale of the real estate located at there. She wasn't even selling the house to you. She was trying to sell the house to someone else because they closed out your file because they knew you didn't have the real money to pay for it. So you saying the case, there's nothing. This what she tried to say on her live, that the case is still ongoing. How can you have an ongoing case when they already sold the house to someone? That's an even bigger indicator that what you tried didn't work. They sold the house to someone. But this is the disingenuous part about these gurus. She already knew that. But she would still come online, keep acting, people thinking that it's going. And they like, we with your sister. Yeah, keep going. You dummies. You dummies. It is further ordered that the recorder of Marion County shall remove from its records all indications of defendants having any right, title, or interest with respect to the real estate located at 5710 Brentwood Road, Marion County, Indiana, including the UCC finances statement as instrument number blank in the office. This is the part where she thinks has anything to do with her. Right? This is what she thinks. Security in the amount of $700,000 is set, but it is contingent on the sale of the property. The security will be held in escrow by plaintiff's counsel, meaning if you wanted to maintain and come in and say, nah, Your Honor, I own this. I really own this. The judge is saying remember, this is a temporary restraining order. This is a temporary restraining order, TRO. And the feds is under Rule 65. But the states is quite similar. So the 700,000, right? Plaintiffs, Ms. Short, has to put 700,000 in escrow because this is a temporary restraining order. So they have to put 700,000 in escrow just in case Kimberly Short and the attorneys are wrong, because they have to give security to the court in order to, when they grant the temporary restraining order, they have to provide security to the court just in case your injunction or your restraining order has actually harmed another party. That has nothing to do with you getting she thought that security was like hers or a win for her. She didn't even know how to interpret temporary restraining orders under the statute. And if you read the Indiana statute under temporary restraining orders and all other statutes, it tells you the person applying for a temporary restraining order, even in the federal courts, they have to give security to the court to indemnify just in case your TRO or your injunction was unnecessary and it caused harm to the other party. But in her mind, she thought that was something favorable for her. That's all. Look, somebody look, I'm swearing it's it. And she thought she was about to win. I told you, they all misinterpret statutes. They have no understanding of what they're reading. They take it at a literal. She don't understand this is in conjunction, because if you read here, it says, but it is contingent on the sale of the property. So during this proceeding, if as Ms. Short sells the property to someone else, 700,000 has to remain in escrow until this is over with. Duh. I told you. It's no different. It's the same thing with all of them, y'all. They have none of them ever really started out studying deep dive. All packets, documents from other people. Never no thorough understanding.
And you know what's crazy is that even though it reads that way, I can bet my bottom dollar that it's a title company that's holding it in escrow. It's not necessarily the plaintiff. So
Right.
even if she was to try to spin it some type of other way, all you would have to do is just call the title company. They'll tell you.
Yes. It was the title company held it. That's it. It's not held for anything based on what Kenyana Stone thinks. It's more procedure than her thinking it's a win.
Right. So it's just gonna read like that on the paper, but if you
Right.
can actually afford a mortgage, you would understand that. You know what I mean?
Right. I told you, every process that they do is to circumvent the normal way of doing things because they can't do it the normal way. And all she did was believe that there was a secret account somewhere. Okay, think about it. She don't really have to work hard for that 1.7 M's. She didn't have to give all her life savings and investments where she got skin in the game. She all thinks just for the sole purpose of just being born in America, everybody has all this secret money. So of course, that mindset, they're going to start. You can tell what their mindset really is and how they're nothing more than consumers with mindsets, economic slaves. Because as soon as someone tells them they could get something without having any skin in the game, It's always a $1.7 million home. It's always a $500,000 home. It's always a $2.7 million estate. It's always a $20 million estate. But if you ask them in your everyday real life, are you doing the same thing? Are you sitting out applications for those things in real life without this? The answer is no. So these processes are only enticing for the low hanging fruit.
You're rocking with the best.
Never fails. Now, this is Kenyana Stone's answer. Kenyana Stone, I'm not lying on you. This is your answer. At all times relevant herein, Kenyana Stone, the lawful diplomat with record of diplomatic status in the United States, organized in the American state, Indiana, Kenyana Stone, having a state nationality as Indigenous American Indianian Hoosier, trustee of, stop right there. So Kenyana Stone, when I said you put that indigenous stuff on your paper and you say, no, you didn't, I didn't know what I was talking about, this is what I meant. You might have forgot, but this is what I meant. This is what I meant, Kenyana, when I said you put that indigenous stuff. This is what I meant right here. I meant this right here, Kenyana. This is what I meant. That's what I meant. So there ain't no clear. December 13, 2023, this is 5. The trustee of the Kenyana Stone Revocable Living Trust is a private trust. Don't we talk about this stuff, y'all? Kenyana Stone asserts the court may or may not jurisdiction over the subject matter of this action. Proper venue in Marion County, where the real estate property is situated in Marion County, Indiana. Defendant objects and denies the facts presented in paragraphs 1 through 24 in the motion for temporary restraining order and preliminary injunction. Defendant objects to order granting plaintiff's verified petition for temporary restraining order. But Kenyana Stone, I thought you said it was working out in your favor. Why are you objecting? The language that we read with the court should have been reading like it was in your favor. It was all against you. Debt was acquired. Debt has a right of recourse. Perfecting UCC finance a statement recorded in Marion County. And before I deep dive into this, I bet you it's a bunch of misinterpretations, lack of context, and baseless assertions for which she believed the statute says versus what the statute means. Want to know why? Because 99.9999% of people read statutes this way. On June 21st, 2023, Kenyana Stone and Kimberly Short fully signed and executed a purchase agreement wherein Kenyana Stone agreed to purchase from Kimberly K. Short the real estate and improvements located at 5710 Brookwood Road, Marion County, Indiana, the real estate. Kenyana Stone and Kimberly K. Short completely signed the purchase agreement, accepting all offers and counter offers attached to the purchase agreement. Kenyana Stone believes that the submitted true and accurate copy of the purchase agreement filed by plaintiff is materially altered, contract concealing the signatures of the seller, Kimberly K. Short, and seller's agent signature, Melissa Cutts. See attached to this answer a true, complete, accurate signed purchase agreement. Closing date was set for July 5th, 2023, in which it was amended in the contract to July 10th, 2023, due to seller Kimberly Short needing more time to remove all her personal property from 5710 Brookwood. This transaction took place around the holiday, July 4, 2023. Kimberly K. Short signed and agreed to have all property removed by July 10th, closing day and final walkthrough. The agreed purchase price and accepted offer for the real estate was $1,700,000, with payment to be in cash with no financing requirement. See, we don't need to stop. That's the nucleus right there. Payment is to be in cash. Here we go. This is where the sovereign citizen, what do they call it? Semantics games come into play. I can see it right here. In section 4, this is where she's going to try to justify something that we all just read that the government said is not legit. Now, this is their mindset. You can get perfect, straight on the face, legal authority saying, no, this is not what it is. And they will still try to justify it. It is this way. It is this way. Here we go. Kenyana Stone acted in good faith. How do you act in good faith when either you're going to pay in cash or you're not? How is that acting in good faith? Either you have the money or you know, we're not real money. Acted in good faith by providing payment for the real estate property. Payment was mailed to 14817 Miami Lakes, Florida. Bank United Treasury Managed Department. Overnight mail via FedEx with providing tracking number. Delivery status shows delivered. Thursday, July 27, 2023 at 9:37 a.m. Signed by W. Fernandez with proof of delivery by online FedEx tracker website. So I hope she doesn't think that just because they received it, that it's good. I hope she doesn't try to go and say tender of payment is discharged. That's another sovereign citizen thing. I hope she doesn't believe that if I give you a check and you take my check, the debt is paid. Not knowing they got statutes and regulations for reversing payment or non-sufficient funds. The only thing is when you get a check, you got to process it, bam, fast. You can't get it and hold it for 6 months. You have to process it fast. In the Century 21 Act, Check 21 Act, that's another thing you just learned that you didn't know exists. It tells you, get it, deposit it, process it. But if the check gets kicked back, there is no discharge there because the money was never really there. See, this is the part that they really know about real money because they've been using cash, buying things their whole lives. But this is where the semantics game comes into play when they're trying to justify something that has no legal basis. This when they play game goofy, like they don't know how everyday transactions work. Now there's another secret method that everyday transactions don't mean this, it means this now. Bank United Inc. is the recipient and acceptance of notary certificate of service, including documents, instruments, special letter of instructions, certificate of ownership, beneficial interest, purchase agreement, settlement statement. Why would there need to be a letter of instructions if what you're doing is the normal process? You don't need to instruct them on processing it. They know how to process these things. If you were to give them a certified funds check from the bank manager signed, and the bank holds that money in escrow until they cash it, there's no instructions to do. They already know what to do. By the fact that you need to give them instructions on a process that is very standard and normal, and they do trillions of dollars a day, it raises suspicious off the break. Why do I need instructions on how to process this? We already know how to process it. We have a bank that the Fedwire Fund Services. We just process it there. We take an electronic image of it, send it up to the Federal Reserve. Federal Reserve is going to pull the funds from a legal valid account. If there's no legal valid account, the Federal Reserve is going to kick it back. They're going to kick it back to the bank. Bank going to kick it back to you. Like, where's their instructions for? Unless you're trying to circumvent the normal way that you know you can't produce. Kenyana Stone was never provided in writing or verbally from Bank United Inc. or from Trademark Inc. that she was being refused for no funds received as payment. Kenyana Stone alleges that she has not failed to make payments for the purchase. The burden of proof lies on the plaintiffs to prove upon request for accounting that funds were not received and no funds were available. For commercial law, uniform commercial cost, secure transaction states upon request for an accounting means a record authenticated by a debtor requesting that the recipient provide an accounting under the unpaid obligation secured by collateral and reasonably identifying the transaction or relationship that is subject to the request. That doesn't even apply to you because no money was ever sent. You're quoting the statute. They're not a debtor to you. And she's really thinking that she's the creditor in this situation. There is no, they told you the money didn't go through and you kept putting it off. And once they realized, no, oh, we about to get into that. Kenyana Stone is requesting full accounting with respect to real estate property collateral. Plaintiff alleged that payment request was refused. In pursuant to Indiana Code, negotiable instruments, tender of payment, that a tender of payment of an obligation to pay instrument is made to a person entitled to enforce the instrument. The effective tender is governed by the principles of law applicable to tender of payment under a simple contract. If tender of payment of an obligation to pay instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent to the amount of the tender of the obligation of an endorser or accommodation party having right of recourse with respect to the obligation to which the tender relates. This statute is inapplicable because you enter a purchase agreement, not a legally binding obligation. See? And by her citing the statute, she don't even realize it killed her whole arc. And this is the same thing that the lawyers looked at, and it's the same thing the judge hit on. Look, to pay an obligation to pay an instrument, like a bill, a statement. You signed a purchase agreement. It's an agreement to buy. Meaning, was it a legally binding agreement to buy? No, because people back out of deals all the time. So this doesn't even apply to you because there was no obligation. It was an agreement, not an obligation. And these are the nuances that if you was to go to court, that's exactly how they would argue with the lawyer. Hold on. There was no obligation for my partner to, like, I can't sell. It was an agreement. And if you don't meet your terms of the deal by this date, I'm going to cancel the agreement. So this is why I say they don't know how to read statutes and interpret them correctly. So number 6, everything you said, that's another X. Doesn't apply. Misinterpreting a statute is the common thing for these gurus. If tender of payment of an amount due on an instrument is made to a person entitled to enforce the instrument. Let me see. Entitled to enforce the instrument, the obligation of the obligor to pay the interest after the due date on the tender is discharged. Once again, there was no obligation. It was an agreement. If presentation is required with respect to an instrument and the obligor is able or ready to pay on the due date at every place of the payment stated in the instrument, the obligor is consented to have made tender of payment on the due date when the person entitled to enforce the instrument. There is no entitlement on Stone to enforce the instrument because it was an agreement to pay. But you notice 6 and 6C, you notice she didn't break it down how that applied to her. She may did it in 7. Kenyana Stone acted in good faith to tender payment with negotiable instrument. Isn't that the same thing they always say? And that Kenyana Stone was the person entitled to enforce the instrument. No, you're not. Kenyana Stone never released herself or any parties in the mutual release agreement. You're not. Oh my gosh, she don't understand how real estate transactions go. You don't govern that. You don't control that. They could back out the deal anytime they want. Plaintiffs acted in negligence by listing property for sale on July 29, 2023 for $1,750,000. And on October 10th, 2023, there was a pending sale for $1.7 million. Then sold on December 8th, 2023 without any notice to Kenyana Stone, the alleged new owner of the real estate property. So I don't even need the lawyer to call me back. Once that order was removed, they moved on to another party that actually had the money to buy it. So they went with someone who actually had the money to buy it, not someone like Kenyana Stone who didn't have the money to buy it, who was trying some sovereign citizen stuff because she ain't have 1.7 M's. She was stepping out of her league. Look, they sold the house And you thinking that because they ain't accept the tender, they ain't give you this, they ain't give you an accounting, that you own the house. The house is yours now. You done lost your mind. You see, when I said they already sold the home, Kenyana Stone was on live and said, no, they didn't. No, they didn't. They ain't sold the home. This is why she said, I don't got to read my court case to my audience. This is why. But she'll make posts about what's going on in the case, but she ain't go live and review her case. I thought you was a teacher. Look, right there. December 8th, they sold the house. On November 28th, Kimberly Short texted Kenyana Stone alleging that she may have been misinformed and would like to make things right, that we had already signed papers at the title company, and she wanted to honor that Kenyana Stone was first. She would deal with the new buyers that were going to close on November 28, 2023. Kenyana, that's based on the premise that you actually really have the money. So basically, she's trying to be fair. Like, hold on, if you really got the money, hold on, I'll put them on ice. But if you really, that's only Kenyana Stone is being disingenuous at this whole process because she knows she doesn't have the money. That's why she did that check payable to the U.S. Treasury. She didn't have the money. The lady is thinking people are engaging in real estate purchases in good faith. The lady would have never extended that to you. She knew you was trying this garbage. Kenyana Stone expressed to Kimberly that I only wanted to act in good faith to resolve the matter. It just needed more time clarifying the information due to the fact the title company and bank failed to respond and failed to prove and respond. No, fuck all that. That instrument that you tendered is frivolous. It doesn't work. No money's going to be transferred. So what other acts of good faith are you talking about? You about to tender real money now? No. They know what they're doing, y'all. They know what they're doing. This ain't nothing. They know what they're doing. And this is what these teachers teach y'all to be, to move around the world being disingenuous. Plaintiffs have not shown Kenyana Stone did not secure funds. Yo, if that 1.7 million would have really hit, you to be in the house right now. But if that 1.7 million would have hit, you wouldn't even be on YouTube doing what you're doing because you already had 1.7 million in cash. You would be on more bigger things. On or about October 4, 2023, Kenyana Stone overnight mailed a notary protest evidencing dishonor, another sovereign citizen tactic when they don't accept your sovereign citizen documents. Now you want to fight. To Bank United, giving Bank United opportunity to cure and address the instrument security received by Bank United with proof of delivery and signature of the receipt of the payment and trust property. Now she thinks those are securities. I told you they all got a vague meaning of security, vague meaning of this. They don't really understand. Bank United was given detailed reason for notice pursuant to, none of that applies, was given 10 days of the receipts to respond to the notice of dishonor due to the emergent matter concerning the payment. Bank United failed to respond in the course of fair deal and continued to default breach of their fiduciary duty because they already got notification that it was fraudulent. On October 11, 2023, Kenyana Stone recorded the finances statement with the recorder in Marion County, listing them as the debtors and her as the trust secured party. She acted in good faith to secure all rights, titles, and interests in collateral related to real estate property. Plaintiffs granted security interests the moment Kenyana Stone had an enforceable legal claim or lien on collateral that had been pledged as purchase money security for the acceptance offer presented in the signed purchase agreement between the Stone and the Short. None of that makes any legal sense. That's just babble. Bunch of words strewn together that looks like it belongs in a legal document. Y'all, she said nothing. Kenyana Stone believes, to the best of her knowledge, the purchase agreement is a secured. Look, this is where she's wrong. And she was live telling her audience this. Kenyana Stone, hold on, nigga, baby, hold on. Right here. Kenyana Stone. Hold on. What I miss? Oh, here we go. Kenyana Stone believes, to the best of her knowledge, the purchase agreement itself, in which every other real estate transaction, the agreement just lays out the terms, how much I'm selling, how much you paying, representatives, this, is it going to be appraised? Are you going, you may cover this? Are you going to cover the closing costs? Are you going to take a little bit out of your proceeds to cover this? Are you going to take this? That's it. The purchase agreement itself is not anything that could be convertible into cash. Wow. I thought you knew accounting. And I thought you knew how the R's work. I told you she don't know. I will expose her on the accounting. She's surface level accounting. I'm deep corporate level accounting. There is a difference. Oh my God, the purchase agreement is a secured convertible promissory note, the warrant of securing payment and performance, securing secure party rights, titles, and interests in a simple contract. Kenyana Stone alleges that acting in good faith is the right to protect the trust and beneficiaries and be entitled to record and enforce the UCC finance statements against plaintiff. Kenyana Stone, with rights that are valid, having legal effect, is rejecting plaintiff's request for terminating the UCC financing statement. A true and accurate, oh my gosh, you lost this. As a result of breach of trust, breach of contract, trust and breach of fiduciary duties, plaintiffs, Kenyana Stone, the trustee, and all beneficiaries have been violated and harmed by experiencing loss due to willful negligence and acquiescence of Bank United Inc. and all other parties representing the seller. Oh my God. Plaintiffs have damaged Kenyana Stone by being the parties to which an instrument was taken for payment or collection or for value with knowledge as to receipt of payment. Plaintiffs are not entitled to recover damage, both actual and statutory, from Kenyana Stone, being she acted in good faith to comply with rights to secure interest in real estate and denies all claims of fraudulently recorded the UCC financing statement. Request for title, Liz Pendez. Counterclaims, notice for notice of pendency when a complaint is filed and disputes on action is pending. It is with good intention that Kenyana Stone requests the court to enter Liz Pendez with intentions to enforce the lien and clarify ownership of given property to protect Kenyana Stone recorded and unrecorded interest in real estate, not giving rise to liability for slander of title. That's something the judge does. Yo, I thought this is bad. This is horrible. Short's trust holding legal title is not superior to the beneficiary of Kenyana Stone. The revoke of living trust equitable rights. You got to secure that $1.7 million home, don't you, girl? Kenyana Stone is the alleged new owner of the real estate. What'd she say? In your goddamn dreams. In your goddamn dreams. You wish you was. I swear to God, you wish you was. Removal of order granting plaintiff's verified petition for temporary restraining order entered December 6, 2023. Kenyana Stone has all right, title, and interest in real estate located at 5710 Brookwood Road. Defendant has suffered irreparable harm due to plaintiffs acting in concert to conceal defendant's right, title, and interest in real estate property, to immediately sell the property, impairing defendant's immediate right to take action to assert any and all right, title, interest, or adverse claims. But y'all realize she's doing all this. This is how I think a lot of these gurus and these sovereign people need a mental health evaluation. She knows no real money ever came. So she wants to play the semantic. Well, you ain't give me a receipt. Oh, I tendered it. Hey, you ain't never sent it back. Oh, you ain't let me know. Oh, let me see. Oh, you ain't never given it to me. All right, so I must be the owner. That's how they think. And Who would trust a person with this, with their own mortgage, with their own autos, with their own credit, hell, with their own court case? Who would trust them? Who would trust these people? Who would trust her? Only the people that believe the same way she does. That's it. Those are the only people that would ever, because anybody else that has a brain would know. But here's something that you could believe in. 1 second. What's good, y'all? So this was in response to my motion to dismiss, because my client was being sued by a company that purchased the debt, and they filed a lawsuit. She owed $17,000. I filed a motion to dismiss, knowing that it was premature, knowing that it may get denied at this stage, because if you look right here, judge's response. But what most people don't understand is that I have top elite court litigation skills, so I really filed this motion to set a trap. So I was ordered to respond. So you can imagine that, well, if they denied your motion to dismiss, and everything in this response was the same thing I filed in my motion to dismiss. See, I set a trap not only for the company, but for the judge too, because I know court strategy and how to structure a motion where the judge is basically can't even rule against me. Now, most people would say, well, if you filed the same things, double down on your position in your actual response, then to your motion to dismiss, there's no way that the case is going to move to pretrial or a conference. They're going to get awarded because you didn't win your motion to dismiss, right? But like I said, I set a trap. Now look at the yellow highlighted. You see, I pretty much handicapped the judge and not giving them a judgment right at the beginning because they wanted a judgment. But what I did with the motion to dismiss, I laid the trap, and then I came back with the response that pretty much handicapped the judge. Now it's our turn. Now we're about to move for summary judgment, and this is going to be another victory. New culture. According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
The new
You're rocking with the best.
Wait till I finish editing my own court. I got to find a way to increase the volume because it was being recorded and you really can't record. So they had to sneak like angles. Wait till you see the next video coming out. I told you, when it comes to litigation as pro se, nobody out here is messing with me, especially not her. So now look at here. Removal granting. All right, we already did that. The immediate granting of a temporary restraining order has violated Kenyana Stone's right of due process of law and equity. The sale was to be prevented to prevent harming potential buyers and new buyers. Security interest in the amount of $700 set contingent on the sale of the property. A security held in escrow by plaintiff's counsel is hereby being disputed for discovery. The preliminary injunction entered be dissolved due to attorney presenting misrepresented evidence that will cause injury to defendant without an opportunity for the defendant to present and answer affirmative defenses. Well, that's what happens in the temporary restraining order. The other party doesn't need to be heard in an injunction hearing, a temporary restraining order. There has to be the likelihood of success, number one, on the merits. The outways of not granting this order would be totally prejudicial and hurt the party requesting the temporary restraining order and injunction. And what's in the best interest of the public. The other party don't even need to know this motion has been filed. This is how you know she doesn't know court rules of procedure.
You're rocking with the best.
She thought that she had to be there, have a chance to respond to a temporary restraining order and injunction when nowhere in the United States of America, in any court, any state law, that's true. But you were citing Indiana codes. I thought you knew that. You left that code out, didn't you? You don't have to be present. That's why it's called a temporary restraining order and injunction, and they got to play security with the court. Duh. Shorts Trust and all parties representing the seller have risked the whole economics of the transaction by having a pending sale and selling the house on December 12th for $1,671,000 to buyers who are now at risk due to willful neglect. No, they're not. The UCC lien recorded at the time of the sale showing property secured by Kenyana Stone Trust is still in effect. Kenyana Stone has not obstructed or interfered with ownership of real estate. Kenyana Stone has only acted in honor. Remember that? Remember, that's another sovereign citizen word. Staying in honor. Stay in honor. Kimberly Short and Kenyana Stone. Plaintiffs are all parties representing Kimberly have harmed Kenyana with reckless untruth that affects the market value of the real estate home, the continued misrepresentation of the square footage, the misrepresentation of non-receipt of payment. You didn't get paid. Oh my, you're going to double and triple down on this argument. Stone alleges that the real estates acted in ways that would be unjust enrichment to benefit themselves and not the best interest. If they really received the 1.7 from you, you would have got the whole. Stop playing these victim stupid games like they took the 1.7 from you and pocket the money and then sold it to someone else. Stop. Y'all got to go to the extremes just to admit that you're wrong. Just to not admit that you're wrong. Nothing what you say has legal validity. The debt collector attorney, oh gosh, and the attorneys for plaintiffs violated the Fair Debt Collection Practice Act. What the fudge does that have to do with this transaction? By harassing, deceiving, ignoring her rights and acting to conceal for plaintiffs. She's all over the board. She's citing statutes that not even applying to her situations. So all those past emails and texts that was getting about her is one common theme. She's all over the place. She mixed accounting with sovereign citizens. She's all because she doesn't have a real understanding of the system. See, this is when she's trying to put this and add this and add this, add parts. But when you have understanding, all the pieces just flow together on their own. She don't have to do what she's doing. Y'all don't have to do it. Take this from here. I'm gonna take this here. Oh, I'm gonna do accounting now. Transfers and service, and I'm gonna do that now. If you can't even put together a coherent argument, what makes you think that you're going to be able to evidence your accounting in a legal form? Oh, by the way, the mere fact that you mentioned accounting and securitization, you do realize that you're going to be subject to a heightened pleading standard. So you got to be 100% on point with what you're saying. You can't even mess up one time when you're going to throw the case out. Want to know why? Because mine was subject to a heightened pleading standard. But the difference between me and you, I just served my parties yesterday. I just served credit acceptance yesterday. Yours got thrown out. My 90-page complaint, 225 pages with attachments, already passed the course efficiency test. Yours didn't. Breach of trust privacy. Plaintiffs have materially altered contract agreements with represents the transaction to lead the court to act and rule in their favor. Kenyana seeks all equitable relief in the performance of breach and plaintiff's delivery of goods that have already been paid for. Delivery of goods. She's saying this. That's not the term. Oh my, she's mixed matching everything. I know you was mad as hell when you got the order. Injunctive relief to stop immediate sale. Yada, yada, fucking yada. Answer filed. Document filed. And this is what she files with the court. This is what she files with the court. A plea of tender. The only people who filed that are sovereign citizens. For plea by special appearance. Who says special appearance? Sovereign citizen. Do you know that special appearance, it's only in the case where your lawyer shows up to court or you got a representative that shows up to court because you didn't make it? That's what a special appearance is. I, defendant Kenyana Stone of the people of the United States of America and Indigenous American Indian, Native Indianian Hoser. But Kenyana Stone, in your 3 lives earlier, you said you didn't use the term indigenous. You said you didn't use that. You said you didn't say that. Why did you lie? By accommodation party for the precedent landed estate, surety for principal, Kenyana Stone, all caps, sovereign citizen. Y'all can't even lie, say this ain't sovereign citizen rhetoric. That's sovereign citizen.
You're rocking with the best.
Sovereign citizen demands the plaintiff to stop action against the surety to recover any damages or interest by reason for non-payment of the said sum, $1,702,087.40. And the declaration mentioned because on the day when the said sum became due and payable, to wit, on the 12th day of December, I acted in good faith, readily available, willing to tender and offer to pay with the plaintiff a secure certificated security, not cash. She wants to pay on a cash transaction, a certificated security, one of the ancient terms that they got from the Black's Law Dictionary that doesn't even apply to the transaction that she was engaged in. Why didn't you just say, I paid it cash? Here's the receipts from my own bank account showing that this money left my account. Why didn't you get a statement from your bank manager saying they did come and withdraw the funds and the money went to bank 1? You didn't have none of that evidence. Anything outside of that, you are just trying to get around with buying a house without using real money. The purchase agreement said cash because there was no financing. And if you was getting financing, you would have to show a pre-approval letter. So stop it. None of that what you tender is legit, recognized legal tender in the United States, because if it was, you would be in the home. I don't care about your version of what you think the law says. No, the actions and results matter. Why aren't you in the home? Y'all can sit there and act like results don't matter. You just sit there and listen to one, hear what you want to say. Oh yeah, that sounds inspiring. Fuck all that. Where are the receipts at? And remember, Kenyana, you said you didn't have to show your case to your audience. So I said, okay, audience, I'm going to show y'all case because she don't want to show it. And I already knew why she don't want to show it. This is why she didn't respond to my text last night. Value that to receive which plaintiff wholly refused. And I've been from that time and still is ready to make the same lawful tender of payment, a pledge certificated security. That's not money. Even if you had a security, the security would still have to be backed by an asset of value valued at the 1.7, or your right to receive payment, and you assign that payment over to them at 1.7. You have neither of those. You're not even in that realm. You're not even in that realm. And I'll bring the same here to the court, ready to make lawful tender to the plaintiff if you will accept the same. How are they going to get paid? How are they going to get paid on this? Payable to the U.S. Treasury. How are they going to get paid on this? How are they going to get paid on this? A self-created check. And let me guess, authorized representative without recourse. Huh? How they gonna get paid? None of this went through. And the biggest indicator is right there. Payable to the United States Treasury. Why are you drawing the check on the Treasury? Why are you drawing the check on the Treasury? You don't need to draw no check on the Treasury. Draw that check out your own bank account. Because that's the only thing that matters to those people. That's what I'm saying, y'all. Y'all can be fooled because y'all trying to get out of shit without paying for, because y'all have a poverty mindset, because y'all have a low-hanging fruit mindset. But the Supreme Elite team, we don't fall for this. We do things the correct way.
You're rocking with the best.
We do things the correct way. One second, y'all. That's what I'm saying. Like you will. That's and they all teach y'all to do this. I will never teach my students to do this because I know she ain't gonna work. But if she really knew accounting, was really proficient in accounting, get the mortgage, make the minimum down payment, and then work your accounting from there. I mean, come on. I mean, I'm pretty sure she knows accounting to the point where she can get a set off on a mortgage or kick up some dust where they're not collecting, or they are stopped from collecting, or they got serious issues with collecting, so they're just going to remain silent and not try to collect and try to regroup and come with the next stages. Those are good victories. Those are good indicators. I mean, you win this stuff in stages anyway. That's a good start right there. If they just automatically stop collecting, if they just automatically stop collecting after they receive your documents, now they got to go back and huddle and regroup. That's a good indicator. There's nothing wrong with that. I mean, I'm pretty sure that if she goes the mortgage way, or if any one of her clients got a mortgage, I'm pretty sure she will be equipped to help because she knows about the accounting. She knows about the transfers. She knows about the transfers and servicing. She knows about these things. I'm pretty sure she will be able to help a client if they had mortgages. I mean, I don't doubt that she wouldn't be able to. I'm pretty sure she'd be able to get this. Pretty sure she'd be able to get this for one of her clients that owed $378,000. I'm pretty sure she can get this and then call the company and confirm, yeah, that's zero's over with. I'm pretty sure she can get this.
You're rocking with the best.
Shit is easy. Child's play. These gurus is child's play. These gurus is child's play. It's child's play. Shit is child's play. Boy, you ain't no fuck. The only person that I'm even going to debate, they have to be a professional in this field. They got to work for Deloitte. They got to work for Pricewaterhouse. They got to work for the top. These social media gurus ain't nowhere near my level. You heard of one of the head honchos meeting with real live professionals, ex-bank examiners for the highest banks in the world. Top attorney at the SEC for 27 years. Secured billions of dollars in fines and the same transactions I go over in my group every night. Come on, stop playing. Shit's on another level, B. Stop playing. Y'all child's play. This child's play shit. This a waste of time for real. It's a waste of time. And look, she this is what she files. And then she files 31 USC section 3113. Oh, give a gift to the, that's that sovereign citizen stuff. What does giving a gift to a government have anything to do with your real estate transaction? And this is what I see when they like, she's all over the place. She's throwing everything in there. This has nothing to do with it. Money, you think money made, like that means like create your own money to reduce the public debt? Like it doesn't mean that. It has to be still legal tender. And this is dealing with reducing the public debt. That has nothing to do with your real estate transaction. Has nothing to do with the purchase agreement. You see what I'm saying? Like you can't even stay on track. None of this has anything to do with court. And guess what you do? You just, and this is what they all do, y'all. They'll read the statute, they'll copy the statute, just paste it on the document. Let's see if she explains why it applies to her. Nope. Let's say she can make a legal connection to 31 USC to 3113, why this should be accepted. Why did you put that there? They all just post statutes and then send. No connection to your case. How is it relevant? Case law that supports your position, because she could never find any that would support this. Look, she does what they all do. Cite a statute. This is what to do. Look, cite a statute and just cites it. In court, you can't just cite it. You got to break it down to many fractions and still make the argument that aligns with the court rules that will give them jurisdiction over the relief that you requested. What is she trying to get out of this? What is she saying? She copies the statute. Okay. All right. So right about here, in this section here, after 2, I'm expecting to me, this is applicable to defendant's case because on the 31 USC section there, in the case of such and such and such and such, the same issue arises when they tendered the payment and the government accepted, Case law has been real consistent on this. The court ruled In another case, in same facts and similarities to your case, I'm expecting to see that. Nope. What did they do? Just paste it and just leave it in there. Just cite it. Just cite it. No break it down, how it applies to you. Just cite it. This is why 99% of sovereign citizen pro se guru teachers are going to lead people up shit's creek. Dead on arrival. All that shit is. Now, this is the proposed order granting preliminary injunction. Okay, so this is the proposed order. Oh, okay. So this is the proposed order that they signed in connection with them because they don't even know. I bet she didn't even sign. I bet she didn't even issue a proposed order to her case. Like, they don't even know how civil works. Look, I bet you just learned something new. That was the way everybody, they didn't even know that exists. I bet she didn't attach an order to her case. Where's the proposed order? So the judge just signed it, like they signed the plaintiffs down here at the bottom when they granted. See, the judge signed the order. See, didn't even think about it. That's what I'm saying. The things that we do routine are stuff that most people don't even think about. They didn't even cross your peripheral. This is the shit we cover. You see, there's levels to this shit. That's a proposed order. Is it saying the same thing in their complaint and motion? And the judge already granted it. Now, this is their answer. This is their answer. This is their answer to hers. Yo, I can't wait till I finish enhancing that video for me being in court yesterday, how the judge overruled their lawyer's objection and reopened the case. Those have been following me with Westlake. I got the case dates wrong. So I filed my notice of appeal because they gave him a judgment in absentee. I got the dates wrong. So I hurried to file a notice of appeal to preserve my claim. So they had another hearing on December 9th. Westlake's lawyer tried to stop the rehearing and go to trial. The judge overruled them. I said, y'all ain't about to get off the way like this. I had the dates mixed up. Hold on. I got a scalpel for your asses too. She asked for a 20-minute recess so she could read it. So the only thing she tried to use, Your Honor, he filed this 45 days late. Wait till I talk. But now you in maneuver. Now you got to understand the rules. Your Honor, no. I filed a notice of appeal to preserve my issues, to preserve my claims when made it right. And then your office called me to when he come down here. So even if I was 45 days late, I still preserve my rights by filing a notice of appeal. Well, yeah, he did file this. You might want to take a look at this. All right, well, let me listen. You disputing it? Yep. Okay, we're going to have a trial. After she said, Your Honor, I don't think, no, don't open it back up, please. Oh, you ain't got to hear me talk about it. I got video of it.
You're rocking with the best.
And this is why I'm hated so much silently, because most people wish they knew what I know. They wish they had the receipts I could show. They wish they could be connected to the professionals like I know, because they've been floating around these spaces for years, paying for this template, paying for that template, buying this, buying that, trying this, trying that, trying this. And they get frustrated because they still never get anywhere. And then they come in and see I'm like me, and the envy and hatred, I can hear it spelling through the screen. But I don't care, because I put in the work. I took no shortcuts. I put in the work. The vigorous hours upon hours, years, weeks, months. I put in the work. So I have the right, because I put in the work. They want to be looked at as a teacher or something. They want it. And who do they go to get their new talking points? Who they normally always biting up? Who makes them change up their whole argument? Who made them stop talking about the 1099A? Who made them stop showing IRS transcripts with that 570? Who made them say the government ain't responsible for your debt? Who made a lot of these teachers switch up their whole thing and take their videos down off the same things when they see me make my videos destroying the arguments? Who made them stop doing a lot of things they were doing single-handedly?
You're rocking with the best.
Who blocks a person who you've never even had contact with, never spoken to, but they block them because they don't want them running across their page and be put on that "Are you afraid of the dark?" OG, damn, it's been a minute, man. But hey, OG, I'm in the middle of a live. OG, it's good. It's good that you're back, man. God damn, man, we was worried about you.
Yeah, I'm back now, so I'm ready. I got to do shit myself.
I got you. We will talk. I got you.
Okay, brother.
All right. OG.
Peace.
All right, peace. OG back. That's a hell of a sign. Get calls all day, emails all day. And they ain't just know, yo, I've been watching you for years. Yo, you been consistent for years. I see your progression for years. Yo, I've been watching you for a few years. Yo, I tried this, what you said. Yo, that shit worked. Yo, thank you for opening. Just not don't beat them paying me just by watching my videos. Yo, I heard what you said. I went back and researched. Now I see what you're saying. Oh my gosh, I've been down the wrong path for so long. Thank you for opening my eyes. This person never paid me for a service. Want to know why? Because I didn't follow the easy route. I didn't follow the wide road. Just follow instructions. Because I knew that it leads to destruction. Want to know why? Because I was in the feds. I was around those sovereign citizen dudes. And they try to tell me, yo, this is the way to go. This when I was green, I ain't know nothing. So my only thing, by knowing legal, I started researching court cases. And when I started researching court cases, I'm talking about 1993, 2001, 2003, 2007, 1989. And then I come on social media in 2022, I started seeing the same processes that the courts had already struck down as sovereign citizen and or frivolous. And they're actively teaching the UCC1 finance statement, all that. So I'm like, maybe they don't know. So I used to be in there like, nah, I don't work like that. Nah. Check this court case out. Don't tell them that. I wouldn't tell them that. Nah. Then I didn't know about YouTube and this stuff. I'm just green. I'm just coming home. I didn't know. Then I realized, yo, why they block my comments? Yo, why I get timed out? Why I get banned for I'm like, what the hell is going on? Then I started getting 20 emails. Hey, I saw you in that comment. You made a comment about this. I'm starting to think it's true because they've been on this process for a few years and I've never seen anything. Hey, I heard you say that. Yo, can you expound a little more? Hey, I heard this. Hey, you made a point there. Hey, bro, just start your own group. I said, fuck no. Hell no. Nah, for real, just start your own group. Just start it. I said, what do I do? Bro, just turn the camera on and just start talking. Hi, bro. I'll try it. I don't think it's going to last long. It's 4 years later. Comes now. Plaintiffs' counterclaims, counter defendants, trademark. Individually, Kimberly Short. By a trust dated May 6, 2003, by counsel and by way of their answer to the counterclaims, if any, contained in defendant's counterclaim, plaintiff's answer to the summons, complaint, and plea of tender. Statements as follows. Now, this is their response to that garbage we just read, Kenyana Stone. That garbage we just read, this is their response. With respect to the rhetorical paragraph 1, counterclaim defendants admit that Kenyana Stone and Kimberly Stone enter into a purchase agreement with respect to the real estate, which contract speaks for itself. Counterclaim defendants denied the remaining allegations contained in rhetorical paragraph 1. With respect to rhetorical paragraph 2, counterclaim defendants admit a dry closing occurred on or about July 10, 2023, with no funds received from the borrower. Counterclaim defendants assert the parties' contract speaks for themselves. With respect to rhetorical paragraph 3, counterclaim defendants admit that the agreed upon sale price for the real estate was $1.7 million and assert that the purchase agreement and settlement speaks for themselves. That's what I'm saying. It speaks for itself. Normal. Hey, this how much I'm selling for? All right, this how much I agree to pay for? Hey, are you gonna cover the closing costs? All right, seller, they usually be covering the close. All right, we can speed it up and you cover the closing costs. Hey, this need a septic. All right, I'll do the septic, but you're going to have to knock like $10,000. How about this? I'll do the price here and I'll cover the closing costs and get that septic inspection. That's all purchase agreements, real estate transactions, just hashing out the deals. Who gonna pay for this? Who gonna get this? Who closing this? The percentage here, how much they getting, how much. It ain't nothing about certified, certificated security, certified, sophisticated with certificated, valued security, principal, document, instrument. Has nothing to do with a real estate transaction. With respect to rhetorical paragraph 5, to the extent allegations are made regarding non-party bank who's not a party to the transaction, counterclaim defendants are without information to admit or deny such allegations. Counterclaim defendants deny the remaining material allegations contained in rhetorical paragraph 5 of the answer. So basically saying the bank is not a party to the transaction. So they ain't got the only thing we know. Basically, they saying we don't know nothing about that payment instrument shit they got going on over there with the bank. Only thing we know is no funds were ever received. That's the only thing the lawyer, hey, whatever you got to do, but no funds were received. To the extent rhetorical paragraph 5 constitutes requests for the counterclaim defendants deny that they're in the possession. Counterclaim claim defendants deny that they are in possession of any monies, funds, or other properties of defendants, counterplaintiffs, for which an accounting could or will be required. So since you're the counterplaintiff now, Kenyana Stone, now you have to prove by a preponderance of evidence that they're in possession of it. They're denying that. Remember you said the burden of proof is on them? Now, since you're the counterplaintiff and they're the counter defendants, now the burden of proof is on you. What's good for the goose is good for the gander. Now, as the counterplaintiff, you can't rely on the counter defendant to prove your case. You got to prove your case how you prove your case. And this is why 99% of sovereign citizen teachers and their students fall flat on their face, because they can never substantiate anything that they claim from a legal standpoint. You can't rely on them to give you the accounting. You're the counterplaintiff. See, I didn't rely on credit acceptance to give me the accounting. I didn't ask them for an accounting. I told them what the accounting was. I didn't ask them, well, how does your financing structure go? And how does it actually send them their own model? I didn't ask about the numbers and how to break down what these numbers means from an accounting standpoint. I think Kenyana Stone knows accounting. She knows securitization. So you should be able to break it down. I didn't need them to give me accounting. I broke it down. I told them, nah, this is how your accounting goes. This is how it goes. This is how your accounting goes. As a matter of fact, I don't owe these amounts anymore. And I can prove from a legal standpoint that I don't owe if this matter was to head to court before I actually filed the lawsuit. I can prove that I don't owe these amounts. As a matter of fact, here, look at all these attachments. See? I can prove how the finance charge is really broken down. I can prove what really consists of the finance charge. I can prove how you do all your metrics, how you measure this, how you do this, what goes into this, what goes into that. I can prove it in the goddamn court setting. I can prove it administratively. I can prove it on a beach. I can prove it on a phone call. I can prove it off the top of my head. I can prove it off the top of my head. Hey, before I filed the lawsuit, this is stuff like this took place before I filed the lawsuit. Way before I had officially filed a lawsuit 2 months later. I mean, it used to say the remaining balance after they got my accounting, my own audit on them. It used to always say the remaining balance, 2024. Everybody got credit acceptance. You check the portal, that remaining balance will be right there. You won't get access to your payment history, your documents. I can't even print out everything that I paid because they just wiped it away. There's nothing there to see. Auto pay taken off. I done forgot about that. They done took that off. That's what I'm saying. Like, it's just child's play, man. Told you, it's just too easy. They don't know accounting. They can go say it all they want. They don't know accounting. They can go cite the accounting, the ASC. They can cite it all they want. They don't know it. They don't understand it because there's many moving parts with it. They think that just that one section right there, and they don't. There's like 30 different moving parts to it. This is how they know this is what I'm saying. They can regurgitate it. They may get some information from someone. Now they start teaching it, but they don't really understand it. It's many moving parts to it. You got to learn about 5 different transactions inside of the overall transactions, how each transaction is measured, how each transaction is accounted for, what metrics they're inputting at this stage, how much they move for this, how much they allocated for this, how much they move for this. They got about 5 different sub accounts set inside to take portions of your interest payments. You got to know which each account goes on, and then you got to be able to reflect it on the balance sheet and measure that on the balance sheet, and then do your inputs and calculations to take away from default risk and transfers and all that. Then you got to understand what's the actual real value. Come on, you think they know that? They would love to have that document where I broke it down. Oh, they would. Oh, everybody, all of them would want to have that. Oh, they would. The one we did in day 2 of the class, the way he was breaking it all down, how it applied from securities law, accounting, the advanced accounting, and how it reflects on tax law, matching the tax laws and the rules and the actual forms you need to use to evidence it from a federal tax purposes, then your claims in a legal standpoint, and then your set-off rights from an accounting standpoint. They would love to have that document. Oh, they would. Oh my God. If they got access to that document, oh my gosh, they can sell that shit for $5,000 and their students are going to pay for it. So they will look at their gurus like a god if they had that document. That's only if they had that document. If they could only get their hands on that document. If they could just only get their hands on that document. You know what? I ain't even about to show y'all the first page of it. Nope. I was about to. Nah. You got to join the real masterclass for that one. And what comes with my masterclasses, you're not going to be so much about me telling you what it is, how it goes. I'm going to give, how I do it is I give my breakdown of it. But the main thing that I do, you're not going to hear so much of me saying how it goes. You're going to hear a lot of all different professionals in that field breaking it down. And then only thing you'll hear me see, y'all, see, that's what remember we going over Supreme Elite Team Group? Remember I was telling you, bam, remember you see what they saying? Oh, yes, in court, the lender will be subject to this. Okay, y'all remember we was talking about that in class when we was going over the balance sheets and the court cases. All right, look at this professional. Michigan Law Review, Law and Mary, XCC staff, but all that shit. So that's how I do it. It's professional. Like, only thing you'll see is, damn, Thomas is saying this. All the professionals are saying the same thing. All the top lawyers and academics in the world are saying the same thing. Every single thing, it's whether you're in Italy, Europe, Japan, they're all saying the same thing Thomas is saying. They're all saying the same thing. Then we move to cases. Oh, Thomas, you ain't got no goddamn case law where everything you saying the judge is confirming. The judge has ruled in favor of the same ways that you're teaching. See, then we get to the case law. Look at all these cases. 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 All these court cases. Come on, man. Come on, man.
You're rocking with the best.
You're not just going to get a recording of me trying to interpret what it means and being vague on the face to make it seem so easy that all you got to do is this. You're going to really get it broke down like you're in a real corporate accounting room. I mean, because after all, obviously after they got my documents. See, obviously, I must have said something. I must know what I'm talking about. Because they don't ever do that. But obviously. Well, Thomas, what about they'll still give you a payoff quote. Like if they give you a payoff quote, if they give you a payoff quote, that means the debt's still valid. Yeah. That means the debt is legally still valid. If they got the payoff quote, you know, you can click on it and get the payoff quote. Yeah. If they give you the payoff quote, then the debt's still valid. The NA doesn't even matter if they give you a payoff quote. Yeah, that's very true. But the thing about the payoff quote is they actually have to give you a payoff quote. They actually have to give you a payoff quote. Let me redact some of my account number, personal information. So I'm just gonna, because they got my account number at the top. But they would actually have to give you a payoff quote. Yeah, you're right. The payoff quote, they should be able to, you should be able to click on it. It tells you, here's your payoff quote, here's the amounts that you still have to pay, even if there's an NA. But the thing is, they would actually have to make a payoff quote available. This is from accounting, y'all. This is all from accounting. All from accounting. Counterclaim denies, and this is what they're doing with respect. Number 8, remain a non-party bank, admitted denied, defendants deny remaining material in rhetorical paragraph 8. With respect to rhetorical paragraph 9, based on information believed, counterclaim defendants admit that defendants counterclaim records in the final statement under counterclaim defendants admit that defendants counterclaim plaintiffs recorded the finance statement under the instrument. Defendant denies the material allegation contained in rhetorical. So they admit that she did file it because she did. So they denied the allegations. They denied. Plea of tender. To the extent of any counterclaims are contained in the plaintiff, to obtain in the plaintiff plea of tender filed in this master, meet your mics, please. Plaintiffs counterclaim defendants denied that defendant counterclaim plaintiffs never attempted to make a lawful payment of cash for the real estate. Denied that they ever rejected any attempts at making a lawful payment of cash for the real estate. And further denied that they have been made aware of any evidence supporting plaintiffs' contention that any deposit of cash to cover the purchase price was made. So basically they're saying is Kenyana Stone never made the payment. Okay. And they affirmative defenses. Basically, her actions denied Stone, not their actions denied Short, not their actions harming Stone. And she's barred to Ms. Stone's breach of purchase result of failure to provide payment in cash at closing, as required under the terms of the purchase agreement. So if you look at this document, they're denying everything. She never received it. And this is the lawyer. They never received payment. Okay. And proposed order on motion for summary judgment. Okay, so here's the motion for summary judgment. Okay, it's basically the same thing. She didn't give the money. She's playing. She don't buy the house. They sold the house. She don't own the house. She ain't got no interest in the house. So all we really got to do is go down to the bottom, because this is an order. Filing a finance statement. Oh, let's just go down to what they want. We all know. We ain't gonna keep going over. Summary judgment is appropriate if no genuine issue of material fact exists, and the moving party is entitled to judgment as a matter of law. Neither the trial court nor the reviewing court may look beyond the evidence specifically designated to the trial court. Once the movement for summary judgment has established that there is no genuine issue of material fact exists by submissions of materials contemplated by TR 56, the non-movement party may not rest on his pleadings, but must set forth specific facts using supporting materials contemplated under the rules, which shows the existence of a genuine issue for trial. So that means Kenyana Stone was supposed to produce more than her motion. She's supposed to produce documents. The plea of tender doesn't mean nothing. That's garbage. She has to produce evidence to say there's a genuine fact. Basically, the summary judgment is what I always say online, that after people like Kenyana Stone files their response, they move for summary judgment. No issue, no legal basis. Let's not drag this out anymore. Whereas when they file a complaint against me or mainly my clients and we respond, they don't move for summary judgment. The judge just orders a pretrial hearing. Now we get to the next stage. See, there ain't no summary judges on this end. So basically, the real estate owner, the real estate people, they're moving for summary judgment, meaning Kenyana Stone has not said anything that supports a genuine issue of fact. If what Kenyana Stone was saying true or her live, the judge would not sign this order. Told you she was on her live lying. That's why she had to go live 3 times. She was lying. And every time I was coming with the facts of the case, she said, I didn't know what I was talking about. I was lying. That the purchase agreement is the money. It is cash. It is the security. Well, the attorney said it's not. And based on whether the court signs this document, the judge is saying it's not. So I was saying it's not. It's earlier. But the difference between her is she's not going to provide any legal basis to say what it really is. With me, I'm showing not me, but a licensed attorney and the court saying it's not. And the bigger, let's not lose sight of the bigger picture, she did not get the home. See, if she would have got the home, I would have apologized and shut the fuck up. But what I'm saying has to be true because I'm saying it's not cash and you didn't get the home with that. And she did not get the home. So if the opposing party fails to meet its responsive burden, the court shall render summary judgment. Let's move down because he's going over the standard. When the non-mover, that's the standards of non-movement. A financing statement is fraudulent if the financing statement identifies an individual debtor as a transmitting utility. Uh-oh. Y'all, now you got to go back and check your UCC1 statements if y'all still using them. If anyone's still filing a UCC1 statement, you are still in the Stone Ages. You have no clue what's really going on. That's for one. And if you've been using that UCC1 as a transmitting utility, now you have realized that everything that you thought you knew has been wrong.
You're rocking with the best.
Everything that you thought you knew about a financing statement, putting the debt as a transmitting utility, this is me telling you, everything that they told y'all has been wrong. Any variations of it, any spin-offs of it, you have been wrong the whole time. So wonder why you send your documents and it never ever happens and you're getting upset because you thinking you're on the right track. No, you was never on the right track. You're still at the beginning stages. Regardless if you've been doing this for a few years, you're still at the beginning stage. There's really been no legal progression. A financing statement is fraudulent if the financing statement identifies an individual debtor as a transmitting utility. As a transmitting utility is for an improper purpose, such as a wrongful interference with another person, or is filed without the consent or participation of the debtor named in a financing statement. So if you filed a financing statement with your all caps as a debtor, it's automatically an improper finance statement because a financing statement has to be signed by actual debtor or representative of the company, not you being a representative of your all cap, because there's a separate identity between me and the all caps. That's just not true. See, now you got to go back and strip all your foundational beliefs and throw them in the trash. Under the disputed material facts shown that the financing statement was fraudulent pursuant to Indiana code. Plaintiffs are entitled to a judgment against defendants Kenyana Stone individually and as trustee, and the remedies according to Indiana code. Termination of sale transaction. The purchase documents set out the terms of the transaction for the purchase of real estate required by the Stone Trust to pay the purchase price for the real estate at cash and closing, and required that funds be submitted to trademark for the closing to be in good funds distributable by trademark to the short trust in compliance. The definition of good funds, United States currency. We're not going to play the semantic games with United States currency. Y'all all know what it is because you went to the store, you bought a soda before, you bought a pair of shoes before, you bought a bag before. You know what it means. Let's not play the semantics game. Just because you don't have the money to pay for it, don't mean you can bring the semantics game. I noticed that only people play these semantics games when they don't have the money to pay for it. And that's the only time they bring these semantics games. Funds, wire funds unconditionally held and irrevocably credited by the escrow account of the closing agent. Certify a cashier's checks that are drawn on an existing account at a bank, savings and loan association, credit union, savings bank. A check drawn on the trust account of a real estate broker license if the closing agent has reasonable prudent grounds to believe that sufficient funds will be available for withdrawal from the account on the check, which is drawn at the time of disbursement of funds from the closing agent's escrow. A personal check not exceeding $500 per closing. A check issued to the state, United States, right. A check drawn on the escrow account. Okay, and a check that's deposited escrow time ago. They go on the statute. Kenyana Stone and the Stone Trust breached the purchase documents by not providing the purchase price at closing in cash or good funds. So it goes back to her method of trying to pay for the purchase price of the vehicle was nothing more than a sovereign citizen site draft drawn on the Treasury. There's a secret funds process instructions. Treasury is going to send you their money if you just follow these instructions. Well, if they're going to send you the money if you follow these instructions, then why don't you go directly to the Treasury and get the money? Go to the Treasury, get the 1.7 for the Treasury, and then buy the home. Why make it complicated by sending the instrument to the Treasury and tell them to do some shit to buy the home? You got the instructions. Won't you mail it directly to the Treasury first? They send you the 1.7, and then you go buy the home. See, that is what gets me about these sovereign citizen people. Why don't you go directly to the Treasury, get the money, and then go buy the home? It makes it so much easier. You make it complicated this way. Because in the back of your mind, you really don't know what it is. If I knew I had money in a Treasury trust fund account and I could pinpoint it, locate it, I'm not going to tell the mortgage people, real estate people to go there. I'm going to go, hey, I need this to buy this home. I get the money, I go buy the home. See, and the thing about it is, y'all know that makes sense. Y'all know that's the legal, that's the logical way. But this, when you get bit by the sovereign citizen bug, everything that's legal, normal, logical, now it has a deeper esoteric meaning to it. Like only the few understand. Like, come on, man. No breach of fiduciary duty. Now they're entitled to judgment as a matter of law. Now this is basically them saying everything that I was saying to Kenyana Stone earlier in her live is right here. None of this legal, none of it. And she argued me down. And she was getting very frustrated. And then she started hailing personal attacks and assaults. You see what she started doing that? And that's when I know when they're getting frustrated. And the mere fact that she went live, I didn't know she was live till she was 30 minutes into it because I was on Facebook. Oh, she went live, she tagged me. But the problem with her is she had to go live 3 times. But the thing that stood out is I said, why don't you show your whole court case to your audience? And she said, I don't have to show my whole court case to the audience. Want to know why she didn't show the whole court case to the audience? Because this is basically the order. Now, plaintiff has requested summary judgment to be entered against defendants on all counts of plaintiff's complaint and on all counterclaims of the defendants. The time prescribed under Indiana Trial Rule 56 for defendants to file a response and designate evidence in opposition to the summary judgment has expired. The defendants filed no response to plaintiff's motion for summary judgment and designated no evidence in opposition thereto. Defendants meaning Kenyana Stone. Plaintiffs have made prima facie case for summary judgment in their favor, with the defendants having failed to meet their burden to raise a genuine issue of material fact and without opposition from defendants. Summary judgment should be entered in favor of plaintiffs. That's the short, the people that were selling the house. Plaintiff's motion for summary judgment should be and is hereby granted for the plaintiffs and against the defendants, and the court hereby orders and adjudicates that there is no genuine issue of material fact as to the claims brought by plaintiffs against defendants or with respect to the counterclaims filed by defendants against plaintiffs. The finances statement submitted by defendants shall be permanently terminated and purged in accordance with Indiana Code. Defendants are enjoined from asserting any rights, title, or interest in the real estate. Plaintiffs are awarded damages resulting from defendants' action, including costs, filing fees, and attorney's fees, an amount to be determined by the court, and the court will set a hearing to establish the damages due from defendant. Not only that you got to pay, but these are your teachings. These are your teachings. Then you got to pay damages based on your information and logic. And you think that if you represent anybody else, that they're not going to be in the same position? Plaintiff's counsel is authorized to release to Dr. Kimberly Short all funds held. Now, this is the part where she thought that she said to her people, the funds are there. Y'all seen the security is $700,000. That she thought those were the funds from the check. Now let's see. Plaintiff's counsel is authorized to release Dr. Kimberly Short all funds held by them. Those were their funds, their own money, from the sale of their house to another person who actually had the money to pay. In escrow with respect to the bond required by this court for the injunction previously entered herein. Remember when I said when you request an injunction, you got to provide a security to the court. The plaintiffs did. Kenyana Stone that the security they provided was the proceeds from that fraudulent check. When the security provided was the proceeds from the house she sold on December 8th, 2023. Plaintiffs are entitled to judgment as a matter of law with respect to all the plaintiffs' claims against defendants and with respect to all defendants' counterclaims against plaintiffs. The judgment is final within the meaning of Indiana rules. Trial procedure as to matters and issues contained here, and there is no just cause for delay, and the same shall be entered. So this order is written by the plaintiff's attorney. It's standard in civil court. The moving party submits an order to the court. Sometimes the judge will say, all right, submit an order to the court and I'll sign it. The only way, if what Kenyana Stone was saying on her live today was true, is if the judge did not sign this order. If the judge signed this order, then she has been lying the whole time. Let's see if they sign the actual. Let's see. Let's see. Let's see. Kenyana Stone, this could make or break you. The judge signed the order. Meaning, Kenyana Stone, you were lying. And you lied for almost an hour and a half to your audience on Facebook Live. I was trying to come up, connection issues. It wouldn't allow me to come up. And you were sitting there lying out of your thick teeth. You were lying. And you knew you were lying because you had to go live 3 times. You lied to your people. Now, all Kenyana Stone's followers, your guru is a liar. The only way I would have to eat shit if the judge didn't sign this order. The judge signed the order. And she got a copy of the order. But guess what? This is not surprising because Kenyana Stone already knew this. Remember? I sent her this text last night. I sent her this text last night. And not only did I send her the text, see, I'm not going to half-ass it. Not only did I send her the text, I sent her a copy of the order. All these pages, 7 pages. I sent her 7 pages. I sent her whole court case. And these gurus will come online and lie, misrepresent the truth, and lie about their losses. They will lie about them. Look, that's a lie. The judge signed the order in favor of plaintiffs, not in favor of Kenyana Stone as she tried to represent earlier. Look, plaintiffs propose findings of fact in motion for summary judgment. That's trademark title, Kimberly Short. That's the plaintiffs and the counter defendant. The order was granted against Kenyana Stone. Kenyana Stone lost that court case, y'all. And she lost bad. Now, here's her motion to reconsider. Look. Defense reviewed. Defendant's motion to reconsider summary judgment. That's her right there. Now, the plaintiff in this case must file an appeal with the Court of Appeals to seek remedy. The plaintiff they're talking about, because it could be confusing, the plaintiff is Kenyana Stone because she's the counter plaintiff. So in order, the judge, remember, she made a counterclaim against them. The judge threw her counterclaim out. Now she, as the counter plaintiff, can file appeal with the Court of Appeals to seek remedy. Or otherwise, this case is closed. Now, the order was signed by a judicial officer. Further order and record shall be removed. So we already know. We already know. This is all the stuff she's going to say. Rules of procedure not being adhered to. Judicial officer granted temporary restraining order, which acknowledged that plaintiff was not given security. All this. Like, it's not even no point in reading, y'all. I swear to God, there's no point in reading because it's going to take up too much time. I got other shit I got to do. It's going to take up too much time. Don't worry about it, y'all. I'm about to head up out of here after this. It's all good. Y'all need to come up. Look, defendant believes he violated the Indian Code by bias. Like I said, we already went over it. You do not need to be around when they issue an injunction, temporary restraining order. They just got to provide security just in case their injunction in an order has harmed the defendant who they filed it against. That's all it is. That's all it is. So we don't even have to get into all that. You're misinterpreting what you're reading. You're misinterpreting the statute. It's not what it means. It's not what it says. What you say, what you think it means, not what it means, not what it says. No, we're not going to get into that. No, I'm not going to break all this down because there's no point. I've heard with enough. Based off of what he heard in the hearing. Yeah, but what he heard in the hearing was attached by the documents, the exhibits. It had your fraudulent instrument. It had your fraudulent finances statement. We already saw that. So we attached documents. So this is just all her. It's just gabble. This is gabblegook. Okay, this is Kenyana Stone, right? This is her motion for reconsideration, right? Let's go to the next one. Now, this is the notice of appeal. This is notice of appeal. Kenyana Stone calls for a de novo hearing, basis of appeal. Kenyana Stone, not the other party, filed the appeal, which you lied and said the other party filed an appeal. This is you, Kenyana Stone, filing an appeal. Motion for waiver of fee. Oh, you know what? I'm not even about to share that. That's your personal. That's your personal. I ain't about to share that. I'm not even about to share that. I seen some with 2 kids and some about making very small money a month. I saw it. I damn sure saw it. I'm gonna go back and take that part out the video. I'm still going to show equity. I'm not going to put your personal like that. But I understand time. I know times are hard. I get it. I get it. But I damn sure ain't about to. I ain't about to go that low. So this was your petitioner for appeal order of fee waiver. It was denied January 27, 2025. This is not the manner in which to file a new cause of actions. This action was resolved. There's nothing more in the case, Kenyana Stone. Kenyana Stone, you told your people it was still ongoing. It's denied. You're the petitioner. They're the respondent. You know what a petitioner is, the ones who's petitioning. The matter was resolved, denied. You see it right there. That's what I'm saying. Proposed order. Motion to proceed on the appeal. Denied. February 4th, 2025. This matter is closed. There is nothing presented to suggest that the case has been or could be appealed. This court will not take actions on any future filings. You lied to your people earlier, saying it was still open. You had your people thought I ain't know what I was talking about that. See, you ain't run across none of these other fake gurus. You're running across, you run across the real deal. See, a lot of them be think, oh, he just like one of them other ones. They ain't really study. He really can't pinpoint everything. No, I'm not these gurus.
You're rocking with the best.
I scalp corporations every day. I scalp corporations. You not run across the hey, he ain't got shit to say. He ain't really can't do that shit. You got the wrong one. I'm the Grim Reaper. You better ask about me, Kenyana Stone. You better ask about the New Culture Empire. I'm the Grim Reaper of these gurus. I'm the Grim Reaper. Motion to proceed in form of papyrus. Denied on its face. Order received from the court. And that's what you filed it. But it was already denied. And this was the order from the court dismissing your appeals, filing that timely. Chief Judge. Appeal dismissed. Now, let's go back. Let's go here. Motion to dismiss. Now, y'all need to come up, y'all. Oh, fuck. The link expired. Expired a minute ago. Order received from the appellate courts. But we can read it. Denying. Issues. Order denying. February 12th. Counterpayment transaction. And that's it, y'all. Motion to reconsider. Denying. Motion to reconsider. Motion to reconsider. Denying. Motion filed. Granted summary judgment in favor of the other party. We just read it. So, like I said, Someone was leaking information to Kenyana Stone for my group. That's why she switched to the accounting. That's why she had securitization. But Kenyana Stone cannot show that anything from her accounting and what she has done has been anything that's up to the level that any of her students could give a real life hope that it could happen for them. Now, this lawsuit against
As a commitment to customer service, this call may be monitored or recorded. If you are a dealer or a financial institution, please press 1.
of court.
We have
The
automatically
lawsuit
found your
has been
account. To
filed.
verify your identity, please enter the last 4 digits of your social security number. Thank you. Your identity has now been verified. All representatives are still busy. Please hold while your call is being transferred to the next available representative.
Credit acceptance compliance team, this is Caprice. I may help you.
Yes, I'm calling about GLE 350. I informed credit acceptance of the pending lawsuit that I actually have on my way to file now. So I don't want to talk about anything legal. I just want to see what the remaining balance, because I was actually trying to print off the payment history, as far as my attachments for, for the judge to see. And I'm not able to print off my payment history or the payments I made. And I was also trying to get the remaining balance feature for the print off as well. But I'm unable to see the remaining balance. It says NA. So those are the only questions I have. Just the remaining balance and NA status, the payoff history, payment information unavailable. So I'm just trying to see if what's the reason behind that, because I did send a detailed email to operations, and it seems like since Saturday I'm being routed to compliance and not just speaking to the regular representative, which is okay. So those it. You could provide it for me, that'd
Okay.
be good.
So who am I speaking with?
Lamont Thomas.
All right. And Mr. Thomas, just for security on the account,
Yeah.
can I have your date of birth and the zip code we have on file? All right. Is that
Yes.
still the best number, or do you want to update that?
No, that's the best number.
All right. Thank you so much for that information. And let's see here. The reason that you're not able to access the information through our customer portal is because of the email that we
Right.
or letter that we
Right.
received
Right.
from you.
Right.
That was actually escalated to our compliance team. So whenever we have, an issue where we're
Right.
investigating something, we place everything on hold.
Okay. All right. Okay.
Okay.
Cool.
What I can do is I can actually email you a copy of your payment history if that's what you are looking
Yeah, that's
for.
cool. Yeah, just the payment history. That's perfect. That's cool.
Okay. Give me just one moment here. Let
All
me
right.
get that up here.
Okay, I'm almost wasted, and my drip is on the spaceship. One more sip, yes, I can taste it. Come to my exact location. I'm so tired of my probation, doing time forever.
As a commitment to customer service, this call may be monitored or recorded. If you are a dealer or a financial institution,
You're rocking with the best.
So I'm done with her. She's been buried alive. I said she was a liar, but I used the court records and the court files and the denials of every motion she filed. She filed motion after motion after motion all the way up to this year, and it was denied. And to the point where they closed the case, they won't even take no action. But I do want to say this last part, because this is the part that it gets real sad. Now, y'all done seen us go over the whole case, but this is what they will actually do. Instead of being honest and coming out with it, and to be honest with you, it was nothing that she should have been actually like ashamed of, for the simple fact that, let me find it right here. I mean, she was trying to do the impossible anyway. I mean, it was never going to work anyway. So, I mean, it wasn't nothing for her to try to like hide or anything. For the simple fact that it was never going to work that way from the beginning. Now, this is, let me see if I can find it right here. Let me see if I'm gonna pull it up right. I'm gonna pull it up right here. I want to pull up this post from her because this post actually says a lot about her integrity. It says a lot about her integrity. It says a lot about she will lie just like every single one of them will lie, and she will lie to save face. So let me go about these posts and read these posts out that she actually wrote. So let me go ahead and just screen. It was someone sent this to me about the post that she wrote, and I thought it was now taking in all the evidence that we've seen, it really just goes to show you the mindset that these gurus don't really give a fuck about y'all more than they give a fuck about what they're putting in their pockets. They don't take the time and details to do these things, man. So I'm about to go ahead and share. Now, after everything we've read, everything we've seen, everything we've heard, this is going to be her take. Remember, she said that she did not have to show her court cases. Remember, she said that. So here goes one. All right. Let me go get another one because they got to be in order. This is not going to make sense. I think that's the first one. And let me get the last one. Ron T, don't worry about coming up, bro. Because I'm about to be done. And let me get the last one. Okay, here we go. All right. So this is the first one. Trust I know God is showing me everything in real time. This is random, but I literally closed on a $1.7 million house in July 10th, 2023. And I studied so long just to know how I was going to handle closing. Fought in court for 2 years, and the case was finally closed back in June 2025. I realized one mistake. I never used the bill of complaint in equity to invoke the equitable jurisdiction at the time, which wouldn't have made no difference because you never paid the money. I wonder why after finally getting into appeals, the judge just kept denying everything I entered and would not explain why. Even though I compelled the answer, he still denied everything. At that point, it was pending Supreme Court review. But emotionally and energetically, I gave up. And the panel closed the case. They had unlawfully sold the house on December 8th, 2023. And the judge said out of his own mouth, the bank has stolen your funds or holding your funds. Do y'all see what I'm saying? But based on everything I've heard here today, I'm going to grant the restraining order and remove your lien on the home from the record, and you can seek damages at a later time. The $700,000 security is reduced to $200,000 contingent on the sale of the home. Meanwhile, pursuant to Indiana Code, security must be secured to deposit escrow prior to issuing restraining order. Injunction meaning security is never contingent upon the sale. It must be. You see what I'm saying? It must be. Oh, shit. It must be. Must be why he issued the order that there was never any evidence to rule in plaintiff's favor. She's lying. The attorney represented it was a whole conflict of interest, and the seller still never showed up to the actual court because she has an attorney. The seller never owned the home. And I learned after this finally reading over the settlement statement, so it made all sense why she never showed her face. It was all a big scheme that I uncovered just by experiencing the transaction for the first time. I uncovered so much with trust. It wasn't a loss because what's for me, I don't doubt anything because I know the Most High is going to double back down on me tenfold. But I truly appreciate what I learned for everything. All the studying is paying off. Our new house is coming for sure. Meanwhile, the house back on the market for sale. The so-called innocent buyers couldn't make it. They are selling the house, and it hasn't even been 2 years. Have a theory about the whole setup, but I'm going to let my gut continue to reveal me what I already knew the moment everything went down. God don't play about me. I know God is real, and God is going to do everything. Remember when I said when they keep using God to cover up their evil deeds? So that was it. All lies. And this is why a lot of people envy the new culture empire. A lot of people fear the new culture empire. And a lot of people are jealous. Main ones who are jealous are the fake ones posing as students, but they really want to be in the position of a teacher. If you want to be in the position of a teacher, all you got to do is do the work, study for years, and then one day you could too be.
You're rocking with the best.
Run it up, hey. I'm cooking up dog food. Yeah. She play with the dick with the tossers. Wow. Smoking that leaf from Toronto. They watching that whisk like a car show. You look like you wanna get shit off your chest. What's up? I thought so. Okay. I'm back in this game now. You sit at the end of the bench. What's up? I thought so. Okay. Yeah, back in this motherfucker like I left something in this bitch. A whole gallon of the white. I'm getting drunker than a bitch. Big straps with the Mac 11s got me putting extendos in the clip. And lay your shit up on the curb. Like you didn't pay your rent. Okay. Got Papa John dope, but no pizza. The dope with his flipping straight O's and the zippers. Right off the Peter Pan, intake at 9 if you open this Millicent with you. My BBE label with guys on the tables. Fuck your start of your Dracos. This map make you jump, no cause cost in the stable. You can scout like potatoes. Shorty saying that I am the one. Who the fuck you think she Billie Jean? She want a nigga, put her on the team. After spitting out my kiss, a Listerine. The flow is bucking like it's Greek the Free. But I keep it 44 like Pistol P. Now when it's shitting on your biggest dreams, about the floor with you niggas, Mr. Clean. I'm cooking up dog food. She play with the dick with the tossers. I'm smoking that leaf from Toronto. They watching that whisk like a car show. You look like you wanna get shit off your chest. I thought so. Okay. I'm back in this game now. You sit at the end of the bench. I'm in the projects like I'm packed with a cake. They ask about it, they say missing no plate. I know the smells when they pull out them trays. There's nothing edible that sits in the place. Right out of prison, I ain't snitching nobody. You ain't jumping lessons up on the base. I need some wild so I can splash in the lake. And I need a rat so I can eat, I'm a snake. My bitch from Louisiana and she Creole with stick and head. Hop and knowledge she clear. We ain't missing, ain't no shots at the feet. The out of time, got them thinking it's zero. Sticks be as long as a cord extender. You get blown like a cartridge Nintendo. Fuck nigga, X you out like you nothing. That's because you be playing the middle. I got an issue with the streets, it's breeding snitches. That's why I'm a family guy like Peter Griffin. Heard about Western Road, think I need a Smith. And issue time with his close, I think he a blister. Matters with the clips, I'm pushing T in my sack. You smoke, and you catch your T at your neck. Alphabet sticks, let the T in the map. Bitch, I'm hotter than few, that's gonna leak out the jet. I'm cooking up dog food. She play with the dick with the tossers. I'm smoking that leaf from Toronto. They watching that whisk like a car show. You look like you wanna get shit off your chest. I thought so. I'm back in this game now. You sit at the end of the bench. I thought so.